Legislative chambers. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Good morning and welcome everyone. We'll begin with the agenda for the Douglas County Board of Equalization. Roll call, please.
Commissioner Boyle, Commissioner Kavanaugh, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Madam Chair.
Here, item A, approval of the minutes of the Board of Equalization meeting held Tuesday, February 3rd, 2015, and item B, call for a meeting and set Tuesday, March 3rd, 2015 as a date for hearing on certified assessment corrections reflecting the addition of omitted property to the tax rolls or increased value on property. Is there a motion to approve?
Second.
Any questions or comments? Please vote.
Motion passes.
Item C, citizen comments. Is there anyone in the chamber wishing to speak to the Board of Equalization about an item not on the agenda? Seeing none, we'll move to resolutions. Resolutions D, E, F, and G. There is one item to note on item E. On CAC 15059 through 15071, those have been asked to be laid over. So if the motion could be on the resolutions with that one change. 15059 through. You got the through? Okay. Hi, Mike.
Mike Goodwillie, Douglas County Assessor Register of Deeds Office. Actually, rather than lay over, I just as soon pull those.
Oh, pull them?
Completely
Okay.
pull them.
All right.
Thank you very much.
Yeah.
Well, basically, there are Turks pending, and the board can't act unilaterally when Turks are pending. We are currently working out a settlement with the property owners, so we've got to go through that process to get it worked out.
Great.
So what I'm trying to do is avoid leading you into making an error.
Thank you. Thank you. Thanks for trying to keep us out of trouble.
I make the motion we approve those less numbers less on item E, numbers 15059 through 15071.
Second.
Any questions or comments? Please vote.
Commissioner Kavanaugh.
Vote.
You got to keep it on. How it goes.
Motion passes.
I don't think we have need for an executive session for this, so a motion to adjourn.
Second.
Please vote.
Just a moment, please.
I know, I forgot the executive session part.
Okay. Commissioner Boyle.
You know, my screen is black. I don't know what's going on, so I've been...
Motion passes.
We'll move to the agenda for the Douglas County Board of Corrections. Roll call, please.
Commissioner Boyle, Commissioner
Here.
Kavanaugh, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Madam Chair.
Here, item 1, approval of the minutes of the Board of Correction meeting held Tuesday, January 13, 2015.
It'll be okay. Thanks, Sam. Thanks.
Any questions or comments? Please vote.
Motion passes.
Citizen comments. Is there anyone in the chamber wishing to speak to the Board of Corrections about an item not on the agenda? Seeing none, we'll move to a report from our Director of Corrections, Dr. Mark Boxall. Good morning.
Good morning, Commissioners.
Thank you.
Yeah, before you, January report for 2015, dated today, February 10th. Enclosure number 1, we're 7 months into the fiscal year, and we remain over budget, and I've explained the reasons for that in my previous meetings with respect to retroactive pay. City of Omaha was billed through November 2014. They paid 90% of their invoices through September of 2014. They have audited invoices through July of 2014, paid audited invoice balances through July of 2014, which puts their balance at $543,684.56. Call to your attention enclosure number 2, community corrections in-house programs. It's a conference call, and I've spoken to JLTV in the past, but there was a conference call with the vendor recently, and they're going to conduct an on-site visit and set up the scope of the project. So the JLTV effort is moving along quite nicely. I'm pleased with that, and I will continue to keep you briefed as we move forward. With respect to the 24/7 alcohol sobriety program, they added 20 new participants in January and finished the month with 71 participants in the program. So we've come a long way, and we continue to march forward. Work Release admitted 65 individuals during the month of January, and those clients donated 954 hours of community service to public and private charitable organizations. House Arrest had 107 admits for the month of January, and they provided 527 hours of community service to public and private charitable organizations. The Reentry Assistance Program, 20 individuals were admitted. Heather Robinson was hired as our new GED instructor, so she continues to get acclimated. And with respect to GED, we have the jail is now an officially recognized GED testing site, so we're happy about that. That's a long time coming. Shortly, I hope to report that Criminal Justice Center at 1709 Jackson Street will be our second official GED testing site. Pretrial services, 19 individuals were referred for priority prosecution, 107 bed days were stayed in January, 228 individuals were placed on pretrial release in January, 683 individuals were managed on pretrial release in January with a 96% compliance rate. Those numbers are down a little bit because our total population is down, traffic is down, or admits are down. Personnel, officers from Correctional Academy Class 14-3 completed their field officer training program and have received their duty assignments. Closure number 5, or strike that, closure number 6, admissions. As I indicated, our admissions are down for the month, and again, that's due to weather-related. And we had 1,439 admissions. We had 1,367 releases. Our ADP, or average daily population, was 994. We've dropped as low as 940, 945 within the last week and a half, so our counts are down and have 7 housing units closed. The United States Marshal population decreased. ICE population decreased. Felony pretrial population is up a little bit. Misdemeanor pretrial population is up a little bit. Female population is up a little bit. However, we still only have 2 female housing units open. With respect to medical, enclosure number 7, there were 1,019 intake screenings, the H&Ps, or health and physicals, 490 discharge referrals, which is, again, I know it's just a number, but that's an important piece. There were 540 discharge referrals. Diana continues to do a very good job for us in making those connections outside of the facilities so that when people are released, they have places to seek services. Closure number 8, mental health, initial psychiatric assessments, 55, initial mental health assessments, 107, mental health and infirmary placements, 29, referrals to community-based mental health services, outpatient psych, medication management, 2, mental health co-occurring disorder treatment programs, 123, mental health therapy, 40, long-term psych facility, 3. So you'll see these we struggle a little bit with our statistics, make sure we were measuring the appropriate variable and component, and we've done that, so they've settled down. The charts that you've asked for are on the subsequent pages, and certainly it's a better view than listening to a statistic. So you'll see charts 1, 2, and 3 on the subsequent pages.
Okay, any other questions for Dr. Foxall?
Yeah.
Commissioner Rogers?
What pages want to talk about? What charts, pages?
Oh, the charts are on pages
Oh, they're
4
not charts related to the health piece, just charts.
4 and 5.
Regular charts. Okay.
4 and 5. And you'll notice this is the first time we paginated everything in the book, so it's a little bit easier to keep track of.
Is there a correlation between, if there is, or what is the correlation between, like, so the pretrial numbers, I don't know if they're going up or down, but,
Down.
okay.
But as our total population drops, as our admissions drop, and pretrial population drops a little bit too.
So is there a correlation between those dropping, but like felony and misdemeanor pretrials going up? Or,
No, not really, because felony pretrial populations, they'll go up and down depending on the time of the year, and if the felony pretrial and misdemeanor pretrial population are showing slight increases, and that may bump those pretrial release numbers a little bit, but not much. We're at 680. You know, in the summer months, we're running 1,900 or better on pretrial release. So
okay.
the entire pretrial population in the jail is down.
Okay.
And remember, our facility is about 2/3 pretrial anyway.
Okay.
So as our population dips, so will those pretrial release numbers.
Okay. Thanks.
Commissioner Boyle?
Yes. Dr. Foxall, I have talked to you before, and we've conversed about who is in our facility. And you've been very good at giving information. It's very difficult, a snapshot of who's in there. And I am a real believer in taking a second look, maybe a third look, at offenses that end up incarcerating people that are, the offenses are rather minor. You know, shoplifting, things like that. And I'm real concerned that we are populating our facility with very minor offenders. And I know it's going to be difficult when you talk to the legislature about decriminalizing and removing things from statutes that are laws. But somehow we need to get a grip on who we're sending to our facility. And you've responded very well with trying to divert them into meaningful confinement, or you've done things that are really, along with Mike, you've figured out, and your staff, you've figured out ways to treat them. But I really would like to see us at some time, not this session, but to get very serious with the Judiciary Committee and talk to them about, you know, we have people who have shoplifted $60 worth of cosmetics, and they're spending, you know, X number of days in our facility. I may be exaggerating, but man says I do that all the time. So, in any event, being Irish...
We all agree with Ann.
Being Irish, it's hard not to. But anyway, I'd like to bring that up and ask that we do that sometime after this session, try to get a relationship with Judiciary and try to move forward on that. I don't know if the county board agrees with me, but I think we need to take a look at that because it really, not only does it cause us a lot of grief and fulfillment, again, a lot of people in there who shouldn't be there, but it also stigmatizes the persons who've been arrested.
You know, I've given that a lot of thought, and for a long time, we tend to focus on the offense, and I agree with you, but then after really taking a close look at our population, I realized rather than looking at the offense, we had to look at it's important to look at the precursor to the offense. And for example, I have 165 people in the facility that are at risk for homelessness, for being homeless. Homeless. So that particular category of people, you're going to see a lot of different offenses that are of the type that you speak about. Mental health issue, which every month I remark about that issue. That's going to drive some of the offenses that you speak about too. So we look to the offense, but it's more important, or is equally important, to look at the precursors to those offenses that you talk about, and how can we do more to prevent homelessness in our community? How can we do more to divert the mentally ill from our facilities? And then you're going to see a decrease in the number of people in the facility for those types of charges. And we're working with the match board, for example, to address some of those issues. We have a summit date. We have a date for mental health jail summit in concert with Region 6 and Douglas County Community Mental Health Center. That's April 2nd. I'll get that information out to you. A lot of the stakeholders have been invited. So we're trying to attack those problems. I don't know. But, we can have a multi-pronged effect, or a multi-pronged approach in dealing with this issue. But if we can impact homelessness in our community, if we can impact treatment for the mentally ill in our community, I think that's going to probably decrease our population a little bit quicker.
That's a terrific response, and I think it's on point, and you're doing exactly what I would hope you could do. You've gone beyond what I'm talking about, and so we'll talk about this further.
Okay.
Thank you.
Thank you.
Commissioner Rogers?
Mark, I want to see if I'm correlating this right. So if the admissions were around 1,400, and then you go to page 8, at least how I understand it right, person comes in, they get admitted, they get a screening, and then after a certain amount of time, there's a follow-up screening. And so...
Yes, that's correct.
For the month. So yeah, person comes in, they get arrested, they get initial screening, health screening. And I'm assuming that the 55 is the initial part of that official health screening on page 8?
The H&Ps are the subsequent screenings. Everybody that comes in within a couple of hours of arriving has a medical intake screening.
And then sometime...
And then there's a subsequent H&B health and physical.
Okay. And of that screening, of the 1,400 people that came in during the month, is it safe to assume that with the follow-up mental health assessment, that 552, would that be caught then?
Yes. And not everybody that comes into the facility gets that follow-up health and physical, because remember, we have a very short length of stay.
Right.
And some of them don't make it. Some of them are here 24 hours, some are here 48 hours, some are here 72 hours, and then they bond out or get time served, cost, and out. So not everybody's going to, not all 1,400 that come in at intake are going to get the health and physical because they're gone too fast.
So this is definitely the low end of the number. So basically that's at least half the people for the month. And I guess I want to see how this transcends for the year. Half the people for the month coming in have some type of mental health issue.
Okay, I'm not sure if you're talking about the H&Ps, you're talking about...
Well, I'm just saying, if they have a follow-up mental health assessment, inmates diagnosed with mental illness.
All right.
So somewhere close to 517 people are diagnosed with some type of mental illness.
And I need to be clear on which number you're talking about. Let me take you back to enclosure
Page
numbers.
8. And follow me. I'm trying to see. So total admissions were 1,439 for the month. That's in the summary report. And then you have the initial screening when they come in. Then you have the HMP a little time earlier where you were saying this follow-up mental health assessment kind of happens. And so then right under that, under the line, inmates diagnosed with mental illness are 517 on page 8, on tab 8.
Okay, but that's not necessarily
after the
just a
follow-up.
look at the intakes. I mean, that's looking at the entire population.
Okay.
For that month. So.
So basically, still, the average daily population is that inmates out is 994.
The average daily population was 994.
Okay.
Okay.
That's the average.
Right. So then you have to go back and look at these numbers in comparison to our ADP. But remember, as I said, we're booking 1,700 people a month.
No, and I know it's a vary, but basically, that's the monthly average, 994. That
Right.
makes the number.
Right.
So out of that 994, on average, at some point in there, 517 people were diagnosed with a mental illness,
Right.
which is damn near half the population.
Well, yes, but
Not counting
coming
people
and
out
going.
at other places.
A better way to look at that, I'm going to have Jared come forward, but a better way to look at that is approximately, and this number's been pretty constant for us, approximately 20 to 24% of our population has some sort of diagnosed mental illness. Okay, you take that one snapshot, and then you begin to look at the acuity level of those individuals. So everybody that has a diagnosed mental illness doesn't have an acute
Right.
mental illness. So we base those numbers on this diagnosis and the people that are being prescribed mental health psychotropics, for example. Do you want to? Let me have Jared talk to you a little bit about that screening process so I don't miss anything.
Good morning.
Morning.
Basically, out of that H&P that
Did you state your name?
Oh, I'm sorry, yeah. Jared Osborne, Mental Health Director for Douglas County. Out of that H&P and that initial assessment, that's kind of where that initial referral to mental health would come. So what you're seeing there for the numbers for mental health would be those that actually had gotten that referral, and then mental health also would follow up with an initial mental health evaluation, just as within 14 days, just like the H&P. Those numbers will vary a little, though, because if someone is returned to the facility within 3 months, we won't need to do another initial evaluation. Correct. With our ACA and NCC standards, we have a 3-month period, and if it's beyond that 3 month, then we go ahead and do another initial evaluation to gather any additional information that's happened in over 3 months.
Right. So if I start looking at this number monthly, if I start looking at the average daily population, which is 994 for this month, then if I look at tab 8, and I look at the inmates diagnosed with mental illness, and I'm not saying they're acute, but still, it's a form. 517 people at that point in the month in the facility of the average of 954 had been diagnosed with some form of mental illness.
Correct.
Okay. Now, I just want to make sure. So that is my safe assumption is somewhere, and I'm trying to see where you're saying with your 20, because 517, 954, that's close to half.
But, excuse me, but probably the better way to say that
And
is,
if you count community corrections and all that other stuff, then that's a whole nother.
and probably the better way to say that is 517 of the
14.
total number of admissions that we had for the month. That's the better of the 1,439 admissions that we had for the month. You can't compare the 517 to the ADP.
Okay.
You have to compare the 517 to the total number of admissions. But again, the better way to look at what a snapshot of the population is those individuals who are on psychotropics, and that gives you a more accurate count of what we're dealing with inside the facility with respect to mental health issues.
Okay. So, understand, but you're dealing with, so that's just another aspect to look at. 311 on psychotropics, which means they're acute to some degree, the other have some form.
Correct.
Okay. All right.
Yeah, and for those on psychotropic medications, some of those may be individuals that, as Dr. Foxall had mentioned, come in, we start psychotropic medications, they may be out 3 days later, but it also includes those that have maybe been there for 6 months, and they happen to be there also in December or January, so those are also included in that snapshot.
Now, I just want to make, are you working on how many of those are frequent flyers? Did we ask you that? I think we did.
Yes, we
Okay.
secured an intern from the University of Nebraska at Omaha, and that intern is working on those numbers.
All right.
It's going to take a little while to put together because that's not a report that's generated.
Nope.
So we're going to have to do that by hand, so it's going to take a little while to put that together.
Okay, no, I know where I'm looking at. Thanks, appreciate it.
But I'm going to muddy the water just a little bit, because the 55 that you look at on page 38, where it says initial psychiatric assessments, and it says current month, that's 55 of the 1,439 admits for the month of January, correct?
Correct, and those initial psychiatric assessments would be with the actual psychiatrist. So those are the individuals that we're looking at psychotropic medications, to be put on psychotropic medications. It wouldn't include those that we do the initial mental health assessment, that possibly it's a lower level diagnosis, that or they don't take medications, they do okay functioning without medications. So the top number, the 55, would just be those seeing the psychiatrist for an initial.
So what I'm trying to do is get a little bit narrowing down on what Commissioner Rogers, so we can follow. So say of those initial ones for January that were assessed and the follow-up was done and then they were diagnosed and medication, how can we extract that number from the total that all of a sudden is being put in all these other numbers that follow?
As far as the numbers
So
of
if you
the
go
total
55 for the month that had initial psychiatric assessments,
Mhm.
then all of a sudden the follow-up psychiatric assessments is 125.
Mhm.
Is that include the 55?
No.
No.
Well, typically within a month, it's unlikely that they probably would have had a follow-up that quickly, unless they are on some kind of medication that would require it, such as lithium. Then they might see them again in 14 days. Now, does that 14 days fall within that same month that we're taking a snapshot? Possibly not. But what the 125 really is probably a more clear way to assess it is those would be the individuals that from the past month or previous months, they either require a follow-up because of the medication that they're taking, or they're having some issue with their medication that would require them to see the psychiatrist again to make an adjustment in their medication.
Okay. All right. Anyone else have any questions for? All right. Seeing none, thank you very much for your report. Dr. Foxwell, do you have anything else?
I have nothing.
No? Okay, thanks. Oh, I'm sorry. Yes, Commissioner Morgan had a...
Mark, I didn't know if you're going to be here or not. On LB 119, it talks about the sentencing. If you are going to be here, we can take it up when Marcos goes through his legislative report. If we're holding you up, I'd rather just take it for a couple minutes now. It's up to...
I'll be here.
You'll be here?
I'll be
Okay.
here.
Thank you.
Okay.
No other questions or comments? Is there a motion to adjourn?
So moved. Second.
Thank you.
Thank you. Please vote.
Commissioner Kavanaugh?
I think you just like say the name.
He's seen if he's away.
I thought you trained him better. Motion passes.
Okay, we'll move to the agenda for the Douglas County Board of Commissioners. Roll call, please.
Commissioner Boyle, Commissioner Kavanaugh, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Madam Chair.
Here, item A, approval of the minutes of the Board of Commissioners meeting held Tuesday, February 3rd, 2015. And item B, approval of claims submitted for payment processed through Tuesday, February 24th, 2015.
I'd move for approval.
Any questions or comments? Please vote.
Motion passes.
Next is the consent agenda, items A through K.
Second.
Are there any questions or comments on the consent? Please vote.
Motion passes.
Next is citizen comments. Is there anyone in the chamber wishing to speak to the Board of Commissioners about an item not on the agenda? Seeing none, we will move to the Finance Committee. Commissioners Morgan and Kavanaugh, is there anything other than the budget report that's presented?
That's it.
Okay. Child and Youth Services, we have an item for consideration of whether to renew the guardian ad litem contracts. This was discussed a little bit last week and brought this week for action. I know that there are people here to speak, and so I would ask that those who would like to speak, if you could maybe start coming down and sitting in these first couple of rows. And as we start this process, I am going to ask that everyone pay very close attention to the light system in terms of speaking. We are extending the time today because we know this issue is very important. But I also will ask that everyone please stay very professional and respectful of each other. And with that, we will let whoever wants to begin.
Yes, Madam
Okay,
Chair,
Commissioner Kraft.
if I may, please. Yes, since some of these people have appeared before us and said the same thing 6, 7, 8, 9, 10 times, and they take this opportunity to denigrate other people who are not here, cannot defend themselves, I would appreciate it if they start bad-mouthing somebody, if you would take the opportunity to cut them off or bring them back into line, because that is not appropriate behavior for this chamber.
And that goes for everybody.
Yes.
Okay?
Can I start?
Yes, and
Because mine's a presentation, or do you want me to wait until after other people speak?
it doesn't matter. You can go first. But I want to
Okay.
tell you that if you want that to be shown on the screen as you're speaking,
Yeah.
we will have to put it on the table over here.
Okay.
And because our little projector thing doesn't work.
I just want to make sure you have the right stuff, okay? So I'm going to do it myself. Are you good, sir?
Thank you, Laura.
Very good. Thank you. There you go.
Thank you.
Uh-huh. Sorry, lots of paper. I don't think I have enough for everybody back there,
They can share.
but I'll give you what I have.
Here, I'll hand it to them.
There you go.
Thanks.
Okay, they should all be in order.
Okay.
Okay. Just 1 sec, I apologize. Lots of paper.
No, you're fine.
Okay, so you want the material over here, is that correct?
Yeah, they can help you with turning the pages if need be.
Yeah, okay. I wonder, can you do that as we go through? That's just the initial slide. Okay. Few last things. And I think we should be good to go. Okay, I want to start off by thanking you all for allowing us to come and speak. I think this really is a very serious issue. I think if we're really going to have honest discussions about the types of system reform that are necessary with juvenile justice and child welfare, we need to allow people to speak, and we need to be willing to and be open to listening to information that sometimes isn't what we want to hear. I also would like to thank all the people that came to speak. Tanya Ward, Avant Soash, Vaughn Crowell, Melanie Williams-Smotherman, Brenda Vosick, Stacy Ryan, Lori Morford Flynn. I hope I haven't forgotten anyone. Thank you for being willing to come here and talk about some difficult things. Let me start by saying who I am. I'm Laura McCormick. I live at 7414 Valley. I have a BSBA in accounting, and I have professional experience as an auditor as well. My daughter and I performed a citizen audit of GAL in 2012 in an effort to convince the board to hire Foley, which was done. Maybe if we can go to the next slide. Let's talk about the state audit parameters. I think that it's useful to point out that Foley's audit was an audit that was performed examining guardian ad litem fees that are paid not only by the Douglas County Board, but also the Douglas County Juvenile Courts. And the contracts are really under the auspices of the board, as you well know. But for those listening who may not be aware of this fact, the scope of the audit was July 1st, 2011 through June 30th, 2013. So any transactions examined would fall between that time frame, and the audit report was issued at that date. I also think we should have some discussion, and I don't want to go too far back into history, but there really has not been competitive bidding for these contracts. They've been in existence for a very long time. The selection of the vendors was very controversial, and some of you are aware of this because you were on this body. So I think that is important to point out. I also think it's important to point out that Ms. Monahan has very strong ties to the Democratic Party. Her dad is a former city council person. Mr. Encontro's registered agent is Scott Lautenbaugh, who sat on the Judiciary Committee while consideration was being given to legislative changes that would have affected these contracts. I think that's an important thing to consider. If we can go on to the attestation audit slide. Ms. Monahan has made lots of comments in public, in fact, just last week, in writing, that Auditor Foley conducted a performance audit, and she also alleges that much of the material should be discarded and considered useless because he did those things. He violated statute and conducted a performance audit. That is, in fact, not the case. The audit that was conducted was an attestation audit. Mr. Foley examined financial records and other documents to try to determine if these people who received these monies acted in compliance with state statute, and I think that is a very legitimate purpose. I think maybe we can move on to the next one, the next slide. This is just a section of state statute that lays out some of the duties for guardian ad litem. I highlighted and underlined the word shall. I learned in a Child and Youth Services meeting from Ms. Urich that shall is mandatory in statutory construction. I, not being an attorney, I believe what she says. This clearly states that a guardian ad litem should have contact with the juvenile within 2 weeks and once every 6 months thereafter, and that's just the bare minimum. And the GAL is to attend all hearings unless expressly excused by the court. So that's some background on what the statute says. The next few charts are specifically from the audit report, and we'll go over those pretty quickly. But you can see the contracts. I'm emphasizing those because that's what's being considered today. This is a chart that came directly, and the page is noted, from Foley's report. There are significant dollars at stake here. I think it's important to point out that Ms. Monahan really does get her $25,000 or $28,000, whether she has one case or 315. I don't know that that is in the best interest of taxpayers or children. Mr. Encontro receives $4,375 a month for each increment of 50 cases. He doesn't have a ceiling, though, and he can't receive any more than $1,050 per case per year. I think there's several things to point out about this system. There's no incentive to close cases quickly. To my knowledge, I don't know that a lot of appeals are being filed on behalf of children. Certainly, I think there's been some commentary that judges have the discretion not to appoint from these contracts. And while that may be true, I think I'm going to give this to you guys here after a bit, after the talk perhaps. Let's just talk reality. In 2010, Judge Sirkovich came and appeared before this board, and the juvenile courts were $1 million over budget. They were $1 million over budget because of treatment costs and attorney costs. And they were informed by you, Commissioner Borgeson, that they were going to need to meet regularly to be very attentive to cost. The notion that cost and politics are not directly related to these contracts and how we're approaching providing advocates to children, I just think that's Pollyannish. I don't agree with that. In any event, I have some material that I got via public records request where Mr. Encontro in 2013 is inquiring of Mr. Curtis why it is that he is not receiving appointments. And I don't know the degree to which the board, the contractors, the vendors are trying to exert influence upon the judiciary, but I think that's inappropriate if that's happening. However, there's a tension with cost. So let's move past that and let's go to the summary of findings. Some of the people behind me are going to talk about some of their personal experiences with these findings that were noted. We can move on to the hearing dates. Again, these are charts out of Auditor Foley's report. They detail hearings in which there was no documentation to prove that a guardian ad litem was in attendance. You can see the same with the hearing dates for Encontro. Thank you. Okay, then the next slide talks about billing outside of the contract. The contract is very clear. The vendors are not to be appointed to anything but dependency cases, and as this chart highlights, that is not what is happening. There are lots of appointments that are made for delinquency cases and not always crossover cases, and I think that's problematic. If the intention is to make it so that these people are appointed in delinquency matters, then the contract should reflect that. The next slide has some criteria by which Foley was attempting to verify. The heading of the slide is Nebraska 43-27201-2D. And so he was posing the question to these vendors, what specific documentation supports compliance with statute and the consultation requirements? I'm not going to read the responses to you because time is of the essence, but you can see that Monahan is hiding, that's my opinion, behind attorney-client privilege and is stating that this material is confidential and cannot be disclosed. On the next slide, we have, these are her words, Maureen Monahan's words from last week. And she is reiterating her very strong belief that she cannot talk to anyone, she cannot disclose any information because that would violate attorney-client privilege. If we then move on to the next slide, this is a screenshot of an email that I received via public records request. Ms. Monahan was communicating with Mr. Bloomingdale shortly before the audit report was released. And if you look at the bottom paragraph, she is making some disparaging comments about the auditor's work, which that seems to be the tact that is taken to discredit the audit rather than acknowledge the very serious deficiencies and exceptions that were identified. In any event, this I do think we need to pay specific attention to. She states that the auditor concluded that several hearings were missed, the wrong information was looked at, court orders are not the official record of the court, transcripts are. Attached is a court order in which I am one of 3 guardian ad litems on the case. The court order does not reflect my presence. The first 5 pages of the transcript show my presence. The auditor acknowledges they were told this, but refused to look at that transcript. The conclusion made by the report is not credible and should be disregarded. If we move on, and you can see that this material was then further disseminated, and you can see the attachments for the order and the transcript to the entire county board. I also have public records requests, via public records requests, identified that Ms. Monahan shared this information with Mr. Curtis. Here's my problem with this. I just listened to her last week explain that she cannot discuss cases with anyone outside of the parties that are appointed. And so I'm not certain that I understand why she would be circulating transcripts and orders to all of these individual people. But that aside, the material, Grimes, let's talk about Grimes. On a case listing from 2012, Ms. Monahan and her firm, they were appointed to represent a child named Grimes. Unfortunately, the material that she provided to you all and to the state auditor is not the transcript from a case that fell within the audit period. It is a case that began in 2014. It has absolutely nothing to do with the audit report. I do not know why she provided you this material, but it in no way relates to the audit. Yeah. Do you need me to be quiet? Okay, can I go through just the last 2 slides and I'll be done? Is that okay? Just the last 2 slides. The next page is a copy of the transcript. I redacted the transcript. The material that was provided to the board was not redacted by Ms. Monahan. And then the last slide, and I will stop, is an email that Ms. Monahan sent to Commissioner Kraft where she states that all Douglas County can do is pay, and evidently pay her. And we're not going to have any honest discussion about all of the exceptions and the failure to provide information to the state auditor, requiring her to attend hearings and comply with state statute. Thank you very much. I truly appreciate it.
Thank you. Next.
I have some handouts, so I hand it to...
You can hand him to...
It's over here.
He's gone. Kathleen.
I made extras for the folks back there, too, if the board would like to give those folks up.
Thank you, Vaughn.
I do have a copy for the control group, too, if you would like them. Good morning. My name is Vaughn Kroll, V-A-U-G-H-N, C-R-O-W-E-L-L. I reside at 15286 Blackwell Drive, Omaha, Nebraska, 68137. Members of the board, thank you for letting us speak here. Commissioner Kraft, I appreciate that I'm able to come here and speak. You are members that are elected by the citizens you represent, and the opportunity to come up here and talk is important to us. Keep in mind, we have an opportunity to talk on the street to the media as well. And our First Amendment rights for freedom of speech to saying what we need to say and what we want to say will not be impeded on the street. So if you'd prefer us to do this in the street with the media, we certainly can. Thank you. Commissioners, I'd like to take the opportunity to comment on the matter of the guardian ad litem contract. Last week, one of your contracted GAL stood here and said the audit has no meaning. I disagree. I disagree as a citizen. I disagree as a veteran. I disagree as a taxpayer. I disagree as a parent that has experienced the juvenile justice system here in Douglas County. Nonetheless, the findings, my family's juvenile court case was May 5th, 2011, and was dismissed June 7th, 2011, so it lasted a month and 2 days. Now, this was outside the dates of the Auditor of Public Accounts, the APA audit. Nonetheless, the findings by the APA in the cases that were examined can be supported by the documents that I just handed out to you guys, to the board. For example, under the summary of comments, the auditor indicates significant errors were identified in the client's listing provided by the Encontro and Monahan to support their monthly payments under the contract. Such issues included reporting cases not covered under the contract. Now, it would be foolish of me to stand here and argue the legal aspects of those documents I just handed out to you. I'm not an attorney. However, you have access to several attorneys, I believe, that sit right behind you there. I have provided sufficient number of copies for the attorneys and for the board. So again, if the board would like them to have them, they certainly can. And again, for the Encontro group, if they would like to have a copy. The first document that I handed out there is an original petition filed by the Deputy County Attorney for account of truancy, falls under Nebraska Revised Statute 43-247-3B. My understanding is that by statute, and I would assume that statute would fall over to the contract, 3A cases are assigned a guardian ad litem. But again, I'm not an attorney. I don't understand all of that. All I know is this is a truancy issue. The second document is page 13 of the oral proceedings held May 5th, 2011. The transcript shows Judge Sirkovich of the separate juvenile court appoints an attorney to represent my son as son's legal counsel in his truancy matter. Judge Sirkovich also appoints Tom Encontro as the guardian ad litem. The third document is the actual orders appointing those two people, the attorney and the guardian ad litem. The fourth document is a motion for temporary custody alleged my son to be wayward. Again, wayward is a Nebraska Revised Statute 43-247-3B offense, not a 3A offense. The fifth document is an order returning custody of our son to our parents. Also shows the private attorney that I hired for my son, Tom and Contra as the guardian ad litem, and the counsel appointed by the court. Now, I don't know what you guys paid the attorney to be there. I know what I paid my attorney to be there, and I paid him handsomely. It appears that we both paid for the same thing, and the county shouldn't have had a guardian ad litem or a counsel appointed there. Again, it appears that Encontro Group accepted a case not covered under the contract, which is exactly what the APA audit pointed out. In fact, the tax dollars seemed to have paid for both legal counsels when I had retained my own. Again, I'd retained my own counsel. If the county board has any resistance from the contract GAL citing client attorney privilege, so be it. Fine. It doesn't prevent the county from hearing testimony from these families served by the GAL contracts, and there is plenty to learn if you're willing to talk to the right people. It doesn't prevent you folks from talking to people like me and to other people that have been served by the contracted GALs. In closing, I encourage the county board not only to end the GAL contracts, but to initiate an investigation into the violation of due process rights by juveniles and their families by any GAL under contract with the county. The APA audit on page 23 and page 24 shows over 30 court dates in which there was no documented evidence to show a GAL attended the hearing. The state must respect all legal rights that are owed to these families, and the GALs not showing up in court at a court hearing seems to not only violate Nebraska statute, but it violates the due process clause. They're entitled to have representation there, and 30 court dates went by that there's no documentation that they did. Again, I appreciate an opportunity to speak here and would answer any questions. But before I do that, on a personal note, my wife and I, as some of you know, some of you may not, were the guests of Judge Sirkovich on the 6th floor for a day. And as we stood there and stared out the window through those thick metal bars, contemplating our situation, why we were here, you could see the entire city of Omaha. From the river clear out west. It's a beautiful city. It's a wide open city. It's a bright, wonderful, the sun was shining. And, we thought to each other, you know what? The city is representative of the people that live here. Honest, transparent, very wholesome people. I think any contracts that you guys enter into on our behalf should be the same. They should be transparent. They should be honest. And that you should not accept ever any situation where your contractor comes up to you and says, the audit doesn't matter. The audit does matter. Sunshine is the best disinfectant there is. Thank you. Is there any questions?
Thank you, Vaughn. I see no questions.
Thank you again.
Thank you.
Thank you.
Next.
Morning, Commissioners. Thank you
Morning.
for creating this opportunity. My name is Chris Costantakos, C-O-S-T-A-N-T-A-K-O-S. I'm an attorney. I practiced in juvenile court for several years. I've served as a guardian ad litem and also court-appointed counsel for parents, grandparents, juveniles in delinquency and status offense proceedings. Have represented the Foster Care Review Board and CASA, as well as interveners. I'd like to talk just on one point, and I spoke in June before this commission, and I appreciated that opportunity. I'd like to talk about the process. In 2003, I was a member of the original advisory committee that the county formed to review the 15 bids that were submitted to the county to be considered for contracts for guardian ad litem services. During our meetings, we were told that the proceedings were secret. We were told that what we said in the meeting stayed in the meeting and could not be repeated anywhere else. When a couple of us asked for permission to bring some of the bidders in so that we could personally interview them to answer some of the questions that were coming up in our meetings, We were told that that could not happen. We were told to destroy the bids at the end of our deliberations. At the end of the day, we voted, and the results of our voting was misrepresented to this commission, and some of you who are sitting here are aware of that and voted against those contracts at that particular point in time. The Attorney General had issued an opinion some months later indicating that he found that there was a technical violation of the open meetings law with respect to how we proceeded as the advisory committee reviewing the guardian ad litem bids. The popular definition of insanity is to do the same thing over and over again and expect a different result. My position today is that to renew these contracts without opening them up, or the process up, I should say, for competitive bidding represents, I think, a continued exercise in bad government. I cannot get paid 1 cent from the county for work that I've done in juvenile court without first submitting a written itemization of the services that I've rendered. I have to show the case name, the date, a description, a reasonable description of what I've rendered, and the work that I've done, and the time that I've expended. These statements are submitted to the juvenile court for approval, and then they are scanned into justice. They then become a matter of public record so that you or any member of the public can see the services that justify paying me with taxpayer dollars. For over 10 years, you have not been able to inspect the same information with respect to the contract guardians ad litem. There's no way of knowing whether the dollars spent represent a good bargain, a bad deal, or whether you're breaking even. There's no way of ascertaining best value here for the taxpayers of Douglas County. I'm aware of the argument that you cannot, or the contractors, I guess, cannot provide you with the same detailed information that any court-appointed attorney can, because somehow that violates their ethical duty to preserve the confidences or confidential information given to them by their clients or information relating to the representation. I would only point out to you that every court-appointed attorney in all 93 counties in the state of Nebraska must be committing ethics violations because they are required by their court directives and court processes to submit the same kind of statements in writing showing services rendered, the amount of time expended, and these also are scanned into justice. When an attorney submits a bill to a governmental authority for payment, it is possible to say, I attended a hearing. I don't know how that violates confidentiality, perhaps charge 4/10 of an hour for that. You may say I consulted with the client or met with the client, although you don't talk about what you talked about with the client. There's where the confidential rub is, I think. In the existing current contracts, there's no limit technically on the number of cases that either contractor can be assigned, so theoretically, all of the cases in juvenile court, all of the guardian ad litem representation, all of the children could be theoretically assigned to these two contractors or these two vendors. To renew these contracts without opening up the process for competitive bidding, then, in my opinion, systematically eliminates a number of qualified, competent attorneys who come from various walks, different cultural experiences, different professional experiences, from the possibility of serving as guardians ad litem for the varied and different types of children that come into juvenile court. At the end of the day, it seems to me the best practice would be for the courts to exercise inherent authority to appoint guardians ad litem. I know you have concerns about whether that's going to be a cost multiplier, and most likely it would be because we have at least 1/3 of the children of the state of Nebraska here in Douglas County, and perhaps that's a discussion, I don't know if it's possible, that the commissioners could have with the bench in terms of what would be some better ways to look at, you know, to scrutinize bills, that sort of thing. But those are my comments this morning.
Thank you, Chris.
Thank you.
Good morning, I'm Brenda Bosick, 1422 South 158 Circle, 68130. I know most of you. I'm the director of the Nebraska Family Forum. We're a grassroots organization primarily comprised of parents of school-aged children and our membership numbers over 800 statewide. As you know, or most of you here know, our group was originally formed to combat the harmful effects of the 2010 truancy law, which was successfully changed last year. On this 4-year journey working with families, I've had the opportunity to personally observe how the juvenile justice system and guardians ad litem operate. Although I'm certainly not as well versed in the subject of guardians ad litem as many of the other people here, I'm pretty confident I have more knowledge than the average citizen who's never been exposed to how our system works, particularly here in Douglas County. I've also read the 2009 GAL report cover to cover, as well as Mike Foley's recent audit. And I'm here today to say that I agree with that 2009 report, as well as the auditor's report. That is, from what I've observed, working with families caught up in the system for the past 4 years, I do not think guardian ad litem contracts best serve the children of our county. The way our current contracts are set up, the guardians ad litem are incentivized to keep children in the system, and that's against everything we know about what is best practice and what is most helpful to kids. I'm also very concerned about the lack of accountability that has resulted because of these contracts. There's no way to verify that the contracted vendors, who are receiving almost $1 million a year combined, are even fulfilling the statutory and contractual requirements for representing the children assigned to them. I watched online the meeting from last week, and quite frankly, I was stunned by the statements by one of the vendors, AKA your employee, our employee, taxpayers' employee, and her adamant assertion that she is not accountable to you or to us, her employers, for the work she does. Even more shocking was the assertion that the legislature has no authority over guardians ad litem and that Mr. Foley's audit is meaningless. I have to say, I don't know why this board would even consider renewing an employment contract with that vendor after hearing those statements. I certainly would not expect to be hired or retained in a job if I made those statements to my employer. In my opinion, it's time to move on. The contracts may have eased a financial burden, but when we're talking about the lives of the children in our community, is saving a little money the most important criteria? I urge you to vote today not to renew the GAL contracts and instead opt for a court-appointed system like most other counties in Nebraska use. Our kids deserve the best, most transparent, and most accountable system we can give them. Thank you.
Thank you, Brenda.
Good morning. Excuse me. My name is Melanie Williams Smotherman. I'm the director of the Family Advocacy Movement, which was founded in 2009 to provide advocacy and resource information to families and lawmakers, as well as to lend voice to those who are caught up in our state's child welfare and juvenile court systems. It's unfortunate that it takes a third party to lend voice to these families, but they can't speak out publicly themselves. And the reason is that when they try, they are threatened, harassed, and retaliated against routinely. Ultimately, their children are held over them as both the reward for complying with any sort of horrific treatment, including harm to their own children, or as a punishment in the form of threats of extended system involvement, or worse, losing their children altogether. During the 6 years FAM has been advocating for families, I have personally reviewed and observed countless cases, each of them sharing troubling similarities and overlapping reports of a lack of honesty, a lack of clarity, poor or non-existent oversight and accountability, disinterested or violative court-appointed representation of parents and children, and denials of basic due process protections. And while on occasion I have shared some of these realities with this board on behalf of these families, they have lived through my experiences here some very rude reception. I've been also welcomed with this reception, which I appreciate. But I think that it is of serious concern that we do have elected officials who seem to scoff at the experiences of families which, again, through me, are airing their concerns to the public and to their representatives. I believe I have more of a right to stand before elected officials for a handful of minutes to report concerns we know exist for citizen families and children than do these professionals who are paid with our tax dollars, who continue defending the very system that is harming our families while financially benefiting themselves. And last week, again, all of us have seen the meeting from last week. Families expressed extreme despondency over the behaviors and tone of a person representing families in this setting, in this court setting, and their children. Someone who basically is placing our county in a double bind by saying, you have to pay me, but you can't ask me for any details or accountability. They also expressed concern about the people who came up to speak on behalf of one of the contract guardians ad litem. Some of those people who have personally affected the lives of these families, who we all know are paid by our tax dollars. I guess the questions that were coming up from families were, did they take the day off, or did we pay them to be there to supply these glowing comments in the absence of actual families speaking for themselves or through their own advocates? You know, it's not just my opinion, even though I'm not a paid professional, I'm not an attorney. It is not my opinion that the system needs reform. We have the most recent state audit, but we also have an exhaustive report commissioned by the legislature that concludes that children are entitled to effective assistance of counsel as a matter of due process of law, and without significant structural reform to create a system grounded in accountability, Nebraska will continue to see poor outcomes for its children. And while I'm not going to stand here today and point fingers specifically at Maureen Monahan and Tom Incontro for those failings, I believe that we cannot also just give these contractors a pass and believe that somehow they have risen above all of this reality with regard to what we have read in very well documented reports. So with that, I am going to say that I hope that this board not only votes to not renew the contracts as they are, but also seriously considers the need for accountability and quality when it comes to representing children and families, and moves away from a contract system into an appointment system. Thank you.
Thank you, Melanie.
Hi, I'm Molly, 1514 North 100 and 4th Plaza. So I was in foster care, and this has like really affected me because I was taken from my mom, kicking and screaming. And as soon as I got into foster care, it was horrible because this lady cussed me out every day. And the kids there came after me, and they called me fat, and we didn't get any food, like we were like basically starved. And they yelled at me, and every time I cried, the foster mom would call me a crybaby and like put me in a room and just leave me there. And then the other foster kids came up and tried to cut me a lot because they just were mean, and they just didn't like me because I don't know. But the foster mom didn't do anything about it. She just kind of let it happen. And then like a whole bunch of people started telling me things about my mother that weren't true. Like Jeff Wagner told me that my mom was bipolar and schizophrenic and she wanted to kill me. And I was sad all the time, like I had really bad depression, and I just wanted to go home and nobody would let me. And they kept saying that my mom was going to kill me, and I didn't believe that. And then I finally got to go home once they found out that the lady who said that my mom wanted to kill me was lying. And that's pretty much what happened.
Molly, I have to give you kudos for coming before us, and I'm sorry, but your comments kind of got to me. But I appreciate you. I appreciate you having the courage to come and talk to us.
Thank you.
Thank you.
Thank you very much.
Next.
That's for me.
Good morning, Molly.
Good morning. Should I start?
You go ahead.
My name is Lori Flynn. My address is 1514 North 104th Plaza. The little girl that just spoke is my daughter, and I cracked her. I am here today to, first of all, ask that if this vote for the contracts goes through, that Commissioner Kraft recuse himself from voting on this. I believe that, and he is my elected official, I believe that he has exhibited an open bias due to his well-established friendship with Maureen Monahan that prevents at the very least a strong appearance of conflict of interest, and along with emails sent to him from Ms. Monahan has an appearance of unethical behavior. I just passed everybody out emails. One is dated June 9th. It's addressed to Patrick Bloomingdale, and it is sent a copy of a motion in my case that she had nothing to do with. Maureen Monahan was not the guardian ad litem in our case. We had nothing to do with her. I find it very suspect that she's, I don't know what that role would be, that she is passing motions that have nothing to do with her to this board. I think it's suspect, and I think it needs to be looked into. The second email, which apparently I'm looking at first. And that one was CC'd to Mark Kraft. You know, and then she goes on to discuss my childhood, living next door to her. Now, I have some different recollections than she is, but I'm not going to go there because I do have some ethics, and I'm just not going to go there. I just think that's inappropriate. I think it gives an appearance of very inappropriate actions. I did watch last week's board meeting. Maureen Monahan talked about ethics and confidentiality. Where is mine? Where is my confidentiality? Because our names were on that, my children's names were on that, and actually it was the motion for the restraining order to gag me, which I was gagged. In this day and age, a judge gagged me, so I could not talk, I couldn't have come here. And she only dropped it when Melanie Williams-Smotherman came before this board and said, it's unconstitutional, you can't do that. And then they dropped it. Molly just kind of just got me flustered. I believe she only cares about ethics and confidentiality when it pertains to protecting her own interests. Because she clearly believed it was appropriate to circulate information about my case and my family to my elected official, and might I say it was inaccurate information too. And also, and this is what I find, this email was also CC'd to Tom Incontro. He again had nothing to do with my case. So I don't know why we're getting dragged into that, but anyway, we were. Let's see, she had no interest in my case or my family, and I believe she used the justice system to pull these things out, which I know that she gets under her contract. So I think there's some unethical actions there. And she used that information to funnel it to Mr. Bloomingdale, Mr. Incontro, Mr. Kraft. And to what purpose? I believe it was to discredit my legitimate concerns and to put Melanie Williams-Smotherman and Laura McCormick in a negative light and discredit their advocacy work. I do have one more thing to say. Transcripts. I still can't get my transcripts. How am I to say, this was done wrong, this was done wrong, this was done wrong? Maureen Monahan herself said, billing and the orders, that's not the legitimate record. The legitimate record are the transcripts. I can't get them. They're mine. My case was dismissed 100%. Done. They sent my kids home without so much as a sorry, we were wrong. And I can't get the transcripts. And I think that that's wrong. I also gave you a court order. One is dated on May 13th. It says, I am the mother of the child, and my request is granted to get the transcripts in my own case. That's June 4th. June 18th, Mrs. Flynn's request for transcripts of these proceedings is denied. Her reasoning, they may be used for an improper purpose. They are being used for an improper purpose. They're being used to hide what is going on up on the 6th floor. We are paying, families are paying, and we can't prove it. We cannot prove that our rights are, we have no rights. We go up there and we are at the mercy. They have our children. My daughter, everything that she told you about the foster home, here's the change of placement that the state, that's the state's paper, they took her out of there. They say, we went there, we observed what she's saying. We observed this foster parent treating this child. She blamed her. She told Molly, she said, I told you not to tell people and to get involved. I told you you could sleep on the couch. That's allowed, and it's paid for. And I don't understand it. I don't believe these contracts should be renewed. Mr. Encontro said he had all those people coming and speaking on his behalf. And afterwards he got up and he said, this is the cream of the cream, the best of the best. In such a broken system, how is that an endorsement of anybody? It doesn't make sense. I'm a family in Douglas County. It shouldn't have happened to me. And again, without so much as a sorry, my case is done. They just, boom, we're going to send your kids home, and oops, oh well. This should not happen. And anybody that thinks it can't happen to anybody here, your kids, your family, it can. They have all the power, and it's all under secrecy. And I guess that I kind of, again, Molly threw me. So if anybody has any questions. But I do formally request that Mr. Kraft recuse himself from this vote, as he's getting, the emails are not addressed to every board member. It's Mr. Bloomingdale and it's Mark Kraft.
Okay.
That doesn't make sense, and I would personally like an explanation why.
Thank you, Laura.
Any questions?
No questions? Thank you, Laura.
Thank you for your time.
Very much.
And next. Good morning.
Morning.
My name is Evance Phillips Slash. I live at 2004 Binney Street. I'm asking that you will hear that there shouldn't be a renewal of the contracts. I don't think taxpayers know what they're paying for. I will tell you that I have a long history with Tom and Control as a guardian ad litem in my family. It's been about 14 years in reality when I sat back and counted it. My daughter was 13 years old. She had a GPA of about 3.75. Her teacher brought her home one day because she scored so far off the chart. She said she thought she was a genius and wanted to see what she could do to help her to be the best that she could be. this girl was truant from school and got into the system, making the transition from grade school to middle school. And that's how she got in the system. While she was in the system, under the courts, a state ward, she ended up being kidnapped and taken across state lines and raped by a man that's my age, married. And he left and went out of town, and my daughter became pregnant as a result of that. Tom and Control was the guardian ad litem. The man came back in town. The child was 6 years old. The child was given to the man. And he stood in a room full of people, including Tom and Control, and said that he had done what he had done. But he didn't know how old she was. He ended up with my grandson. He changed his name. As a matter of fact, they live around the corner from me. And I'm not able to see my grandson because I have to deal with that man that raped my daughter. My daughter continues to have children because she wants to be a mother. She's lost 5 children to the state, a set of adorable twins, a daughter, that child, and the oldest child and the one that was given to this guy I was raising, me and my husband were raising. The oldest child is still in the system. I'm just, I'm a mom, I'm a grandmother. I can only speak from my point of view here. And what I've seen in the years that I've had to deal with guardian ad litems, Tom and Control specifically, hasn't been good. My whole family's been tore apart. My husband and I are separated. I was told that it'd be better for me to not be with him if I wanted to get my grandson back. My daughter, the mother of the children, she's not allowed to come around because I don't know what. But now they're trying to say that she abandoned her children. She did not abandon her children. It's just been a mess, and it's not right that somebody is getting paid so much money to do so much harm. My grandson is the oldest grandson I've been fighting since Thursday, April 8th, 2010, because he was the last grandchild that I had left. And he got shipped off to Michigan about a month ago, a little over a month ago. And I've spoken to him once for about 2.5 minutes. And he was there a week before he even got his medication. Speaking of medications, they were never on medication until they went into the system. And he was crying, like the young lady said. He was crying, and the foster parent took him to the hospital, and they put him on psych meds at age 8. So now he's a child with severe problems. And while in the system, I will put it like this: everything that you don't want to happen to your child happened to him. That's the best way I can put it. And now he gets shipped off to Michigan because he divulged some information to me about how he was harmed in the system by some people that were supposed to be taking care of him. So I just want to say that contracts aren't great. I think taxpayers need to wise up and understand exactly what they're paying for, and I think people get greedy. I think the money gets too good. It's too good, and it's hard to stop. It's just creating a big problem. And we need to open our eyes and really look at what's going on. These are our children. These are our future. Tomorrow, they'll be taking care of us. They'll be in charge. We're hurting them. We're killing them.
Thank you, Eva.
Thank you.
Anyone else wishing to speak?
Hi, my name is Karen Hicks. I am an attorney admitted to Nebraska in 2013. I work in juvenile court. I am appointed as attorney for juveniles and for parents. I also wear the hat of a guardian ad litem for juveniles and parents. Admittedly, since I was just admitted in 2013, my experience with juvenile court and guardian ad litems has been somewhat limited. I haven't read the GAL 2009 report or the audit report. However, I would say that if we're going to, and I guess because of that, I don't really have a lot of background information as to whether or not these contracts, whether or not Douglas County should continue to issue contracts to handle guardian ad litem appointments. I would say, however, that if Douglas County is going to continue to issue contracts to handle GAL appointments, that I think those contracts should be opened to other bidders. I think, as you will see in any industry, the long-term appointment to one individual leaves way for complacency. I think if these contracts are going to continue to be issued, they should be issued on a regular basis and be open to a variety of individuals, so that there's constant review of their work, of their billing, and that just so that they're held to the same standard as the private attorneys who are appointed to be guardian ad litems and attorneys in juvenile court. I believe, in addition to being able to better monitor the process and work that's being done, you also enable perhaps more diversity in the individuals that are going to be wearing the GAL hat in juvenile court. A lot of the individuals that I have seen that are involved in the current companies that hold the two contracts, there's not a very diverse, they're not very diverse groups. But we see a lot of diversity on the 6th floor in juvenile court. The juveniles we see are very diverse, as are their parents. And I think the assistance that they'll receive from their GAL will be better if they are receiving a diverse appointment of GALs. I think as a juvenile, it's going to be, or even as a parent, anyone involved in the juvenile court system, I think it's going to be difficult to actively listen or accept assistance from a GAL who they may feel doesn't understand them or their culture or their background. So while I really can't make an argument as to whether or not contracts should be issued or not, I do think if Douglas County is going to continue to issue contracts, those contracts should be available to a diverse population and open to more than just two groups to bid on them. Thank you.
Thank you. Anyone else wishing to speak? Good morning, Tanya.
Good morning, Commissioner Borgeson. Good morning, Commissioners. My name's Tanya Ward. I live at 4826 South 19th Street. And I also sit on the Learning Community District 5, but I'm not here today to speak to you in that capacity at all. Today I'm here only to speak to you as a mother of a son who was assigned Monahan as his GAL. Then she subcontracted to Senator Pete Persh as his new GAL. This alone is a violation of the contract. This attorney, Monahan, should not have her contract renewed at all. She doesn't even follow the rules. I understand Encancho has $600,000 and Monahan has $300,000 on the line today. But what about the families that they are supposed to be protecting? They're profiting off of them without doing any work. What a great job. Persh harassed my family. GAL Persh harassed my family, calling us on holidays, giving only 5 minutes of notice that he wanted to come in and meet my child. Well, he never came in and met my child. My sons weren't even home on one of the days. He showed up and was on the corner of my home. I looked out the window. There was a strange car, shiny, new, black tinted windows, 2 of them. And in my hood in South Omaha, those cars aren't common. So he sat outside my home while I called desperately to Melanie and said, oh my God, he's here. And he just called. I'm cooking bacon. I'm in my pajamas. My kids aren't even home. So when he did finally make an appointment, one of them was on June 11th at 3 o'clock. My family, I had my oldest son, 19 now. I had him take my youngest son because GAL Persh was only interested in my middle son, claiming false statements that I abused and neglected him, which was all garbage and thrown out in court. On June 11th, 3 o'clock, we were waiting for this man, anticipating him, the GAL, to come for days to meet my child. That's what I've been ordered by the court to do, let him meet my child. This GAL never showed up. He never came. He never called to say, can we reschedule? Instead, he let a 10-year-old boy who is frightened already to death, removed from his peers what he has known, special education child, worried, wringing his hands, pacing the floors. Mom, what is he going to ask me? When is he going to come? When is he going to come? And Persh never had just the decency or professionalism to even just call us and say, hey, let's reschedule. Instead, all our experience was with GAL Persh was threats that I do have the power, he would tell me in his voice, I do have the power to take your son from your home. But at this time, there's no evidence to do so. So why 8 months of harassments? Why 8 months of GAL Persh billing you? And he has never even met my child. He violated the rules of the GALs. They're supposed to meet them in the first 2 weeks. What happened? 6 months, 4 months, 8 months. He never met my child, but y'all paid him. We paid him. Why? GALs are supposed to protect our families, but GAL Persh, in our case, purposely, with the assistance of my public defender, who was lousy, blocked me from all of the hearings about my family. And in the document served to me by the sheriff, it stated that all the hearings and proceedings of false accusations, what I was accused of, abuse and neglect of my child, all of those hearings I was allowed to attend. I showed up at the hearings early. I'd see my public defender and the GALs go into closed doors, and I demanded, can I go in? It's my hearing. I need to be with them. And they told me no. Go back and sit down. An officer came up and stood by me. Go back and sit down. You cannot go into this hearing about your family. However, in that same information from the state, it says that if I was an incarcerated person in prison in Nebraska, and these hearings about my family were happening, they would take me, remove me from my jail cell, in handcuffs, take me to court to speak or to at least hear what they're saying about my family. I'm a free woman. I was a free woman at that time of those hearings. GAL Persh didn't speak out for my child. GAL Persh didn't protect us or our family. Why wasn't I allowed into those hearings? GALs are supposed to protect us. Why is this GAL not following the order of his contract? And speaking of that contract, this is a mysterious connection with Monahan and Persh, and I don't understand it. It's called a coalition, I guess. So she gets to choose what attorneys at what time that she's going to put into her coalition. I don't understand that. I don't understand that. So I ask of you, how much money has been wasted over these last few years? Maybe 14 years probably for Evans. How much money is wasted? These GALs are ineffective. They're not helping us. They're not helping our children. They're not meeting with them. They're not counseling them so that they aren't afraid and they know what's going on. Why do we pay GALs? Why is Monahan and Encontro still here? Get rid of them and get some fresh people in that have diversity, like the other lady commented. Where are our black GALs? Where are our Hispanic and Latino GALs and Asian and Sudanese GALs? It's a flawed system, and If you vote for these contracts to be renewed, I'll be disappointed in every single one of you who vote that way.
Thank you, Tanya.
Thank you.
Anyone else wishing to speak?
Hello, I'm Tom Incontro. Good morning. Hello. I just want to clarify a couple of things, if I may. When it comes to diversity, I have 7 attorneys in my office. One's African American. One is of Native American descent. I think we're about as diverse as any office that works in the court system. It is something we try to we heavily recruit. We try to increase. Those efforts are not easy, but that is something that we do work on. So, and I think we've been successful. A couple of things just specifically. I won't get into everything, but one of the things that's being brought up is that we've missed appointments, that we've missed hearings. In that report, you'll see under my group, there were 11 dates that showed that guardian ad litems did not appear for a court hearing. 11 dates. That's over the course of 2 years. And that is we've counted, that is over 5,000 hearings. So it's not 11 out of 50 or 11 out of 100. It is 5,000. And of those 11, we looked at those ourselves and determined that at least 7 of them, there was an attorney there. So I would swear on a stack of Bibles that that maybe there were 4 hearings out of the 5,000 that we did not attend. And it isn't a cavalier, I'm sure. We just don't show up to hearings. I think it's being presented that way, and that's not accurate. Any attorney here knows. Sometimes with scheduling, getting caught up in other courtrooms, things like that may happen. I'll put my 4 to 5,000 against any attorney in Omaha as far as being in court. So that's one of the criticisms that I just don't think is fair. I don't have a problem with showing time. I will do that. If you want to go hourly, I'll go hourly. I have no problem with that. I just would like to hear a solution, something that would allow me to tell the people in my office, the 9 people that work in my office, something that I can tell them, here's how we go forward, here's what's happening. So any solutions that there are out there, anybody that has a better way to do this, I'd love to hear it. I'd love to be a part of it. I understand if I'm not. I was an attorney before this. I'll be an attorney after this. I enjoy the work. I want to continue to do it. But I would like to hear maybe more solutions. I think that would be helpful to the overall system. And I would answer any questions anybody would have.
I see no questions. Anyone else wishing to speak? Thanks, Tom. Good morning.
Hello, Maureen Monahan. My office is 1904 Farnham Street, Suite 623, Omaha, Nebraska 68102. Just wanted to clarify a couple things. We have had, over the years, a lot of diversity in our group. The truth is that many lawyers will not take the amount of pay. They can make a lot more money than working under a contract, frankly, both through appointments and private hiring. Currently, in the 5 attorneys, we do have an African-American attorney. We also have an attorney who speaks Spanish, which is of particular need because of many children who are removed are placed with relatives, many of whom only speak Spanish. So if you have a 6-month-old placed in a family that only speaks Spanish, it's very, very difficult to communicate with them and find out what's going on and check on the foster home. I can't speak for Mr. Incontro, but frankly, I mean, considering the sheer number of cases my group has done, I'm willing to bet that there are hundreds of parents out there who absolutely despise me because I stand in court and say, I don't think it's in the child's best interest to go back with you. I've represented babies that have been scalded, children that have been beat within an inch of their life, children who've had spiral fractures, which if you don't know what a spiral fracture is, if you've ever taken a stick and twisted it until it shreds. And some of those children beg to go back home so they can prove that they can be good. They deserve the beatings. I have no problem standing up in court against a parent and saying, this child should not go back to you. And I've done it hundreds of times. And I will continue to do that if that is what's in the best interest of the child. And I know that doesn't endear me to the parents. I appreciate that anybody who's been in the system probably does not like the system. And you would not find a defender of the system in me. I took a case to the Supreme Court last year that was not only the first case of its kind in Nebraska, but the first in the country to challenge the state of Nebraska from interfering in our families' lives without due process. In other words, they can't just knock on the door and say, hey, we heard you have a problem with your kids, and we just want, if you just do these services, we won't take you to court. You can't do that. That case, for procedural reasons, went back to court. It's going back to Supreme Court, and I'm going to be the guardian ad litem fighting for the families, for the state not to be able to come in and do that. If you talk to people in juvenile court, the problem is the Department of Health and Human Services and not having the proper service providers in the state to help families in a timely fashion to get their kids back. It's not always the parents, it's not always the guardians ad litem, it's not the defense attorneys, it's not the county attorneys. The county attorneys are charged with filing. If you listen to some of these comments, it sounds like Tom and I started these cases. We didn't. There's a whole system to investigate. And the county attorney determines whether to bring a petition, and then the judges sign after looking to see if there's enough evidence. That is the system we're in. It's a constitutional system, and it requires due process. Now, I somewhat agree with Chris Kostantakis that the contracts do not allow accountability. I have reviewed the ethics rules. I have asked for an ethics opinion because the current ethics opinion says a guardian ad litem cannot discuss any non-public information. So I certainly can say, hey, here's a court order, and here's what happened in an open court hearing. I can discuss any of those things. I cannot discuss non-public information about any case without a subpoena or court order. Ethics Opinion 11-05 is extremely clear about that. I have asked to see if there's any other wiggle room. Currently, the way for transparency and accountability is to not have contracts. It is to go through the courts, to have court appointments. The judges don't just pay us. There is a motion. There's an opportunity for a hearing if someone wants to challenge that. And under a court order, a judge can then question a guardian ad litem about the items. And in fact, you will see that happen in a case called In re Anton C. It was about 11 years ago. You certainly can do that. I do not know how under a contract situation, even if you itemized within the context of trying to protect your client's confidentiality, how you would, if you wanted to question me, say, hey, so-and-so said you didn't see the kid on that day, how I could discuss that with you. So even if you get, say, fine, you can give an itemization, any further questions can't be answered. You run into the same ethics wall. So I'm not hiding behind ethics. I'm standing up for them. And I would think that you would be proud that a citizen of Douglas County who you deemed worthy of a contract believes that the duty to the client is paramount. And actually the duty to the client sometimes does come across against transparency. Any attorney will tell you that. If you do not want transparency, then you contract. We are still accountable to the judge no matter what. A judge can always ask me and order me to answer, when did you last see this child? And they've done that. We submit reports. We often put pictures in. We do all kinds of things. I worked for Legal Aid prior, which was the prior contractor. At those meetings, sometimes as staff meetings, they would say, going on home visits is not attorney work, have the paralegals go. There were 3 attorneys in our group who rejected that, and that's why we bid on the contract, because we wanted to do it better than previous contractors. Somebody might have a better idea. I'm not against that idea. Certainly, any contract would still have ethical problems if it had transparency that you're asking. But every day, I hope that I do a better job. I hope every day that I learn a little bit more. and that I learn from any mistakes I make, because just like everyone else, I sometimes make mistakes. But I'm not going to compromise the duty to my client because someone wants to serve a personal vendetta or make a political circus. And that is exactly why this information is improper to even be discussed. I've seen children's rights violated here. I have seen county commissioners express that they have power over the judges and influence over a court case. That is, as an attorney, abhorrent. And this is very simple. You learn in high school there are 3 branches of government. The duties and the regulation of lawyers belong solely to the judicial branch. The legislature or the executive can say all kinds of things, but that duty, that regulation belongs to the judiciary. If there was any merit to any of the comments made in today or previously, then they shouldn't have any problem making a complaint to counsel for discipline, because that is who regulates lawyers. And in the context of the counsel for discipline, we can talk about a case. We can defend ourselves in that context because we're defending our bar license. That has never happened. They come here because they can talk without being challenged, because we are bound and we cannot talk about a case. If you want to regulate lawyers and make sure they do their job, you should tell every single one of them to go make a counsel for discipline complaint. Because I cannot, Tom can't, no attorney can. And there are several attorneys here, and I think many of us, I think people have a hard time understanding what a lawyer does, and that's fine. That's why we go to law school, and that's why we have to take a bar exam. And we also have a character and fitness part. If you want accountability and transparency, you have to have due process. You have to have a way to allow parties to defend themselves, and that is through the courts. If you choose not to have that transparency, then you can contract. And really, those are the simple answers. That is up to you. Contracts require 2 willing parties. I will tell you that if I was in your shoes, after the 4 years of the attempts to ask the county board to influence court cases and the perception that you have power over lawyers' duties because of contracts, I would vote to not have contracts, because you don't have that power, and you shouldn't allow the perception of that power. And unfortunately, I think contracts give that. If anybody has any questions, I'm certainly open to answering any of them.
I see no questions. Thank you. Anyone else wishing to speak? Hi, Justin.
I'm on the other side for the first
Yeah.
time. What do I need to say?
Your
Justin
name
Wayne,
and address and who you're
8937
representing.
North 56th Avenue Circle, Omaha, Nebraska, 68152. Justin Wayne, W-A-Y-N-E. I literally just walked over from court and was having another conversation. I walked in at the exact time that I think I should be here. I have nothing against the 2 contracts. I work both with them in the juvenile system. As you also know, I'm an Omaha Public School Board member. I'm not speaking on behalf of Omaha Public Schools. I always have to say that. I'm speaking here as a private attorney. I think it's critical as we move into the juvenile system and reform juvenile justice that we increase our awareness for diversity and people who can relate and understand the kids that we're dealing with. And again, I have no bones to pick with any of the contracts. However, there are a group of minority African-American attorneys who have been talking about how do we come together and bid on something like this, i.e. the GAL. However, it's not even open for a bid. All I ask is that if we're going to do a contract, and I'm sitting on the side of the table that you are sitting on, that it's an open process, that it's fair, that everybody can participate in and have a chance to participate in this process, because I think it's critical when we're talking about dealing with young people. I think they know how to understand young people. I think both of the contracts do a fairly good job of working with kids. But from my perspective, I think it's critical that we have people who are from the community, in the community, and know the community to be a part of this process. And I'm not saying go yay or nay either way. I'm just saying that the process should be open and make sure everybody has an equal chance of participating in this process. And I guess I'll open it up for any questions if that's the process.
Thank you, Justin. Any questions? Seeing none, anyone else wishing to speak? With that, we will move to the item. Let me read it here. The item for consideration is whether to renew the guardian ad litem contracts, and we are scheduled to take action today. And I will open it up for comment. Commissioner Boyle.
Yes, I appreciate that. I do want to say to every one of the speakers, seldom have I agreed totally with advocates for a position, but today first of all, the presentations were calm, well thought out, and you made excellent points. I really feel that I honestly agree with everything that was said. There's something went wrong with these contracts, and years ago, when they were passed, I remember clearly, first of all, I believe the board, as far as political leanings, I believe there were only 2 Democrats, and I was one of them, and there were 5 Republicans. And so there was really no partisan voting taking place. Mr. Kraft was not on the board at the time that these contracts were approved. I was very critical, first of all, for what we did, because I was happy with legal aid. I thought they were doing a terrific job. But I think some of the commissioners just did not support legal aid. So this came about, and we suddenly were putting this out to bid. And I remember clearly that we had a group of African-American attorneys, several women who came down and pleaded to be included. And I thought we were trying to do that. And I don't remember the irregularity, but there was something really odd that happened when the recommendations came, and it wasn't a pleasant experience. So in any event, if there is a lack of reporting from either of the contractors, I will accept the blame for that as one of the commissioners. My recollection was that I voted against a couple of them, but the records show apparently that I didn't. But I will accept the blame for not watching that contracting and the writing of it well enough to bring about the kind of accountability and transparency that is needed and was needed. It did bother me a great deal because my heart is in including people. When you look at who comes up before the judges, they don't look like me. They don't look like my grandkids, although we have some interracial families going in my family, and I'm happy of that. But when the children come up, they're not the same. Everybody is, most people are not at the same culture, the background. And another side note is, many of these children, and I know one of the families here has had their 12-year-old child brought into the courtroom in chains, leg chains, hand chains. Senator Chambers has a bill to stop that, and I'm going down to testify, if I can, if it hasn't been heard already, to stop that practice. In any event, what happened, the contracts didn't work. However, I have to say I do respect the work that I've been exposed to by both Mr. Encontro and Ms. Monahan. They will continue to work in the system, but we need a lot more people like Karen Hicks and Justin Wayne and others to step up, and I'm so glad that you're doing that. You got a lot of guts starting out in 2013 and doing what you're doing. I believe the better system, and the reason we really went, I think, to the contracts was we were trying to get a handle on the cost. It was going through the roof. We had a lot of out-of-home emplacements. The costs were climbing. I mean, it was approaching $4.5 million is my recollection. It was really over the top. And we have no control over the juvenile court system. It's really none of our business. And the fact of the matter is, as brutal as it sounds, we are here to pay the bill. That's what our role is, and we really can't do much. We can't do anything to direct them as to what they're supposed to do or we want them to do. So that really was what I think drove us to this contract system, hoping that we could curb the costs. And whether or not that worked is really not the issue. But so many problems have occurred that I think it's time for us to give the responsibility back to the judges. They should be making the appointments. It is their responsibility. They account for and watch the expenses. We have no staff to do that. Why duplicate it? So I will be voting to stop the contracting, and I hope that the board will vote unanimously, including Commissioner Kraft. I think he should be allowed to express himself. So I want to thank you again for the eloquent presentations that you made. Heartfelt, truthful, talked about the disruption that's happened in your lives, and you did so with a lot of class. Thank you.
Thank you, Commissioner Boyle. I, too, would like to add a little bit. People can damn me all they want for allowing our citizens who we represent, who are paying the bills for these contracts, to be heard in front of this board. And I'm not going to apologize for that. I will respond to a couple of things. I never, ever, you almost sound like Jeff Wagner standing up here, Maureen. I never said I had power over judges, ever. I have never even spoke with a judge during any of the times that somebody came before this board. But what I was finding was these voices were not being heard going through the proper procedures. I watched a family and learned of a family that was put in jail over an issue. Now, I'm sorry, to me, that's almost like out of a movie. That doesn't happen here in Douglas County, Nebraska. And so that started me to open my eyes, but open my ears to listen to individuals that had been in our system. And we may not have control or power or authority over the system, but we have responsibility to listen to our taxpayers who are being affected by that system. And we also have a responsibility because we are spending over $1 million through contracts to supply GAL services for that court system. So to me, we have a responsibility to listen and to let them be heard. So I will never apologize for that, ever. Even if I'm not in this seat, I will still push that we allow citizens to come before us. That's our job. If anything we do during these board meetings, it's to be open to hear from our taxpayers. They are our bosses. And to listen to some of the unbelievable things these families are going through within our court system, I have to sit back and say, when Molly was speaking, all I could see was my children standing there. How would I feel if that was my child that had gone through that? I would be devastated. I was devastated listening to Molly. But for my child to have to go through that, so if that isn't good enough for my child, why is it good enough for all of the people in Douglas County? I say it's not. And so on these contracts, I think we should stop the contracts. I think that we should have further discussion. There are really kind of three options I see that we could proceed, and Mr. Encontra wants a response as to what to tell his staff. We can go out for RFP again, and I would bring some pretty hefty accountabilities clauses within those contracts, or within that RFP if we did that. I would open it up, as Ms. Hicks and Mr. Justin said, to a more diverse, more contracts. That's one way. The second way is we could appoint, or let the judges appoint, just go back to the appointed system. I do still question the accountabilities, but I'm learning a little bit more about the billing process on the appointed side, and I think there's probably some accountabilities there that we don't have that may be able to help. And the third, we've talked about very briefly, and that is to bring it in-house, hire a director, and that director be responsible for hiring of GALs to provide the services to the courts. So with this motion today, with this action today, it's basically the action as to whether or not we want to continue them, and then we would have to give notice to the two contractors. And then very soon thereafter, we would have to decide which way we want to proceed in providing these services. So I, too, as Commissioner Boyle said, appreciate all of you very much. I just can't imagine what you have gone through as families. And if anything, that puts a more burning desire inside me to make the changes. We have an initiative that's going on that I think we would be able, are going to be able to make some needed changes. There is legislation that is on the table that may or may not help. I'm not real sure quite yet. I think there's things Laura McCormick has talked about in terms of that complaint process, appeal process, which is very important, I think, to the whole entire process, because in my opinion, the reason these families are coming to us is because nobody else is listening. And I can give you Bond's gazillion letters that he's written to every type of jurisdictional body there is to write to be heard, and he is being totally dismissed. So I think we have work. I think we are a part of the work that should be. We are a part of the system that needs to be a part of the solution, and that's what I hope that we will be able to work towards, depending on how this vote goes today. But I will be voting not to renew the contracts as well. Commissioner Duda.
Thank you. This is very difficult. I, of course, along with many of the people on this board, voted to put these contracts in place. And I recognize most anything, I mean, I don't know where Justin Wayne went, but when you're on the school board, everything has to do with emotions. And they don't, I mean, they're volunteers. Every issue that comes before them, it's about people's kids, and they're very emotional, and they're tough issues. I get that, and now we've entered into that world a little bit. I don't think that because people have had bad experiences in juvenile court or experiences that they didn't like, I'm not sure that blaming that on our contracts I'm not sure that I accept that premise. I don't think the contracts are to blame for people having experiences they didn't like within juvenile court. I thank Maureen Monahan and Tom Encontra. They've done what we asked them to do, and I believe they have saved us hundreds of thousands of dollars through the years. And it bothers me very much to see those savings go away in a tight budget. I hope this doesn't mean we have to raise taxes. But everybody in this room, it's about kids, so taxes don't matter. Taxes do matter, and we have to do the balancing act. Very emotional issues, but then taxes are, we have to be doing everything we can to control taxes. I will be voting against renewing the contracts, but my rationale is different than what I'm hearing here. I'm doing this largely trying to cooperate with Senator Christ and the legislature. This has certainly gotten their attention. Senator Christ has proposed some changes to what guardian ad litems do. Perhaps they're good changes. I'm not speaking to that, but there are changes coming. It seems very evident that there are changes coming. When Chris Constantaco said, at the very least, bid this out again, there's something to that. But changes are coming. We can't bid it out right now because of the changes coming. I think it is time for a clean start. Doesn't mean we won't look at doing something again in the very near future, but we need a little more guidance from the legislature as to just what the duties and responsibilities of a GAL are. I appreciate everything that Tom and Maureen and their staffs have done for us, and it is my hope that they will continue to receive a lot of the work. I mean, they're appointed by the courts. They don't get this work because we put these contracts in place. They get the work because the juvenile judges appoint them. And so I'm hopeful that the juvenile judges will continue to appoint what I believe are good people doing this work. So maybe down the road we can look at trying something again with a little clearer vision. We've learned a lot through this process of what's good, what's bad, what we would like to see, what we don't want to see. We are very limited in our power. I cringe at the thought that this is going to cost us hundreds of thousands of dollars, and nobody's mentioning that. And in a budget when we've got to make $2 million worth of cuts, to not raise the tax rate, and I will not raise, I'm with you this year, PJ, I will not raise the tax rate. I have no intention of raising the tax rate again in the foreseeable future. So these are cuts. We've got to make that much more cuts now to our budget to make up for this. I think our costs are going to be going up. But I still think the time is right to end these contracts and then consider how we want to be going forward, but I think we have to wait to see what the legislation does. So I thank Maureen and Tom and their staffs for everything that they have done for us, but I think the time has come to end these contracts. Thank you.
Commissioner Kraft?
Yes. I would like to thank the Encontro's team and the Monahan team. They have done a very good job, and as Commissioner Duda said, they are appointed by the judges. So I'm going to backtrack. When we voted to extend the Monahan contract, I believe the words I used were so that the contracts would expire at the same time. And in discussions with Ms. Monahan since then, I have indicated to her that I was not going to vote to renew the contract. And she's back there nodding her head yes. So she knows I'm not going to vote for her, and she's known that for, what, 6, 7, 8 months? Something like that. Now, a lot of what we heard today, we'd hear about anyways because of the foster care service system, because of Health and Human Services, because if you read the Foley audit report, you will see there are also problems with the attorneys who are not under contract. It's a systemic problem throughout the state of Nebraska, not just in Omaha. And Senator Christ and others are going to be bringing changes through the legislature. So again, I'll agree with Commissioner Duda. We need to sit back and wait and see what changes are brought forth before we even think or contemplate how we're going to react. Thank you.
No other lights are on, and with that, would someone like to make
I'd make a motion not to renew the contract.
Second.
Any further questions or comments? Please vote.
Motion passes.
With that, that was the last item for Child and Youth. We'll move to Human Resources. Weekly Personnel Report from Civil Service. That is the report as presented. If anyone doesn't have any questions or comments, we'll leave that. Weekly CAO report on staff assaults. Oh.
None of them are. There was one assault at the CMHC, but did not result in any serious injury.
Okay.
CMHC.
All right. Thank you. Next are legislative issues. The first being a resolution opposing Legislative Bill 111 relating to elections to require presentation of a government-issued photographic identification document to vote, assigned to the Government, Military, and Veterans Affairs with the hearing date of 1/23/15, which occurred. and this was put on by Commissioner Rogers. And then also, another one relating to the voter ID is item B, LB 121, relating to elections to require voters' identification for purposes of voting and to require the use of secret ballot envelopes assigned to this was assigned to the government, and this was heard as well. Commissioner Boyle?
Yes, I remember when this was before us, or considered a year ago, or when last session, or a couple sessions ago, there was a letter from the Douglas County Election Commission talking about the cost. And I don't know if that's in here or not, what the financial impact is, and particularly of the envelopes. That's really an additional cost that would be quite expensive. And it's kind of interesting, too, because the history of casting ballots, you know, after we vote, we are not permitted to put the ballots in the box ourselves. And many people have objected to that over the years because they feel they're not casting their ballot. But the reason goes back to the old days, and this is where I have to break Commissioner Duda's heart, but there was a very strong Republican machine operating here.
Oh, those were the days.
Those were the days. Anyhow, and so what happened was there were separate ballots. There were many ballots, and today there's usually only one, although there can't be more than one. And so what would happen is that someone would bring a ballot out, and someone would mark the ballot, then take it in, their ballot exchange would start, and so the ballot box was loaded with, I doubt that could happen today, but who knows. In any event, I don't think the envelope's necessary, because we do put it in they put it in a metal container, and you need to see the signatures of the people at the polling place, and then it drops into the box, and that's the end of that. But the other thing is, I mean, the cost of all this is something that I think is unnecessary, and really, it also bothers me that we'll have an awful lot of provincial what do you call them? Provisional ballots being cast by people, and I'm worried about, first of all, the backlog that would occur, and secondly, that there could be people who would be disenfranchised because they can't prove their residency. And that really goes to something that happened just recently, last week. I was at a grocery store in South Omaha on 24th Street buying some spicy food, some spices for good Spanish food. And a woman came up to me who was not Spanish, and she was elderly, and she told me that, she asked me about this bill, and she told me all she had was a Social Security card, and that I don't even see that being permitted. It doesn't show her address or anything, and she said, and I'm not going to carry my Social Security card with me. How do I vote? I had no answer. I mean, I don't know where she's supposed to go somewhere to get some ID. I just think it's unnecessary, and I'll be very candid. Douglas County was the first county in the nation, in the world, to run optical scanning ballots. And it was in the election when Jimmy Carter ran against Gerald Ford. And a young man whose father-in-law prepared the ballots came to me after our primary that ran from Tuesday morning at 5 a.m. all the way through till 10 a.m. on Wednesday morning. Can't we do something better? And he came up with the idea, and I went to see it over in Iowa City. They copied the ACT testing where you fill in the little dots. And that became our ballot. And we incorporated a lot of safety in how the ballots were handled and so forth. But the real danger in counting is in counting the votes. And Hitler said that. It doesn't matter who gets the ballot, but who gets to count them. And there was a case, it didn't involve our company, this company, ES&S, but there was a case in Ohio where someone set up an office across the street from the vote counting operation and hacked the system and changed the results of an election. And they were caught, they were indicted, and they went to prison. So if you want to look at dangers of voting, you look to the counting, not to the common people walking in. That's what I think. This is all focused wrong.
Commissioner Rogers?
Thank you, Madam Chair. Some of the comments that I was going to mention, Commissioner Boyle said, but I want to note, I think there is a provision in the bill that takes into account cost of the ID, but that's just a surface cost, because I think also There's also other things that come with it. I mean, with decisions in regards to having to go and get identification, I think there's a lot of barriers out there transportation-wise for somebody to go get them. I think to reiterate Commissioner Boyle's point, there are a lot of people that are in this realm that if they're elderly, don't have identification or driver's license to things that they can't drive. I think, a year ago we opposed it on cost. I'm asking the board to oppose it on principle because I think it's a answer looking for a problem.
Right.
You sign your name there when you count. This is not the Chicago Daily machine when somebody dead is going to vote. You sign when you're there. So, I mean, this thing of identification preventing voter fraud, I don't think is really valid. And, I want to ask the board to vote against this. I think it's going to, it's been proven in Pennsylvania where it happened, and in other places that is not solving the problem. It is creating more barriers and actually preventing voter participation.
Right.
And so I'd like to ask the board to oppose this in that respect.
I'll second that motion.
Is that for both of them, Chris?
Well, I'd like to take both of them together because to explain 12, there is a cost with it, and Nebraska and NACO did go to oppose to it, but that voter identification clause is in that too, and I think it's there on the same principle. So if applicable, I'd like to move to oppose A and B, 3A and B.
That was my second.
Okay. Commissioner Duda?
Well, I'm going to be a lousy Republican here, although if this is in response to a Republican machine in Douglas County, you're the only one that's going to go back far enough to remember that, Mike. I sure don't. I don't remember a Republican machine down here. But I do remember one single incident. It's funny how things can cloud your opinion. 8 years ago, very sweet older woman constituent came to me looking for help to get simply a state ID. Ought to be so simple. Rick Kubat was on our staff at the time. I assigned Rick to work with this woman. She had a son who's a lawyer. Didn't do her much good because she came from a small town where the courthouse burned down and there was no birth certificate record left. We worked with her for, I'll bet it took a couple of months, and we finally got her an ID. But, I mean, the hoops we had to go through, it was just ridiculous.
Yeah.
So, yeah, this is, I'm not seeing the problem, but I do see some problems with the proposed solution. It's not going to be as simple as people think. So maybe I'm not a good Republican, but I too agree that this is not a good way to go. Thank you.
That's right. That's right.
Well, and I'm going to continue with my mantra of I don't really vote based on parties.
Right.
I vote on the issues. And this issue, I have to agree with Commissioner Duda, though. I haven't seen a problem, or Commissioner Rogers, too. I haven't seen a problem within Douglas County with this issue. Now, if there were a way to issue cards without tying it to the voting process to begin with, I'm all for looking at that. And within this provision, they do talk about the state paying for it. There's a indigent clause that's within this, but again, until we have that system down well enough to where I think it's not a hindrance to people to get those IDs, then I think that we should not support these as well. The envelope with Senator Schumacher's bill, the LB 121, because it's tied to both, I'm going to vote against it, but that portion of that second envelope I actually do like. If you ever had gotten a ballot to vote early, and when you go to send it back, your name's on the outside of the envelope.
Yeah.
And that was kind of an eye-opener to me. It was like, well, gosh, if somebody really wanted to get you, they could just keep that aside and run it through the machine and see how you voted. Now, of course, the election commissioners will say, we get so many of those, we don't really look,
Right.
we don't care, blah, blah, blah. Well, again, being that I'm so apolitical, that I actually think that it could happen. And so there was talk that if a second envelope is an option, I remember Dave Phipps talking to us about a new machine that can trifold them, and so it would only cost the amount that a regular mailing of a letter would cost, not the $15 or $25 plus by adding this second envelope. So again, I'm for listening or maybe further discussing that portion of the bills, but to tie it again to some type of voter ID, I don't think we need that. So with that, we do have a motion to oppose LB 111 and LB 121. And there was a second. Yep. Yep. Please vote.
Motion passes.
Thank you.
Next is a resolution supporting LB 15 relating to juveniles, amending the statute to provide additional powers and duties for guardian ad litem assigned to the Judiciary Committee with a hearing on February 26th. And again, this is really brought to the senators with our help and guidance or encouragement that we look at this. And you have been handed out a summary that has been put together about this whole bill. And in a nutshell, when I read this, it's basically taking, we've talked for a number of years about the Supreme Court guidelines that were established by a group of attorneys that sat down and looked at the GAL system and brought forth some recommendations that I believe a couple of them maybe were implemented, but certainly not the guidelines as proposed in totality. And so what I think this does is basically takes a lot of those recommendations and puts them in this bill to eventually, upon its result, will become law. So again, the hearing is on the 26th. I personally, as I've said before, don't believe that GALs should or have to be attorneys. I believe that every person, including children, deserve proper legal representation when in court, but there's a lot of stuff that occurs prior to that process that I think would be better handled by those professionals that know how to do that work. That was not, I guess that engaged conversation on that part wasn't necessarily liked by the senators. They wanted to keep them attorneys. And so I think the bigger issue on this bill, as we spoke about during the contracts, is that we come up with some type of a process, appeal or complaint process that citizens would be able to go to. And so I hope that we can also continue to have that discussion between now and the hearing and, further depending on where the bill goes. So we are here today to determine if we want to support, oppose, or watch. So we will begin debate on that. The first light was Commissioner Kavanaugh and then Commissioner Boyle.
Thank you, Madam Chair. I am supportive of this measure and have worked with Senator Christ in the development of this bill. And it's good as far as it goes. I think, we're taking some good first steps here in reforming juvenile justice in Douglas County, and frankly, it's about time. We have, in discussions with concerned parties on this issue, received more than one suggestion that we should look into bifurcating guardian ad litem representation between work that lawyers need to do and non-lawyer work. Most people who are familiar with this area, particularly most legal professionals, will tell you that one of the big problems that we have with guardian ad litem here is that lawyers are routinely performing tasks that are more along the lines of social worker tasks than lawyer tasks. And that's not right for a couple different reasons.
First of all, lawyers aren't social workers. You know, we're not psychologists. We practice law. And some of these tasks require the special skills of a social worker or someone with that kind of a background that we don't possess. Secondly, lawyers bill at a higher rate than social workers. And so you're paying someone who doesn't have the training to do social work a lawyer's hourly rate to perform tasks that they're not normally called on to perform in the practice of law. So what we have looked at, particularly relative to LB 15, is an amendment that would address that bifurcation of duties, which exists in many states around the country. And it would have a twofold purpose. First of all, we would give appropriate work to appropriate professionals, legal work to legal professionals, social work to social professionals. And secondly, it would contain the costs of paying lawyers' wages to social workers to perform social worker tasks. I would recommend that in our endorsement of LB 15 that we also instruct our lobbyists to pursue that, whether as an amendment to this bill or as a future agenda item in this area. This is the beginning, not the end of this discussion, both on this board and in the legislature in Lincoln. And so we're taking a first step with the endorsement of LB 15. Senator Christ would be open to favorable discussion of bifurcating the ALJ's duties between those that require you to have a law license and practice law and those that do not. So in our resolution, I guess I would add that addendum that we authorize our legislative representatives to pursue that amendment with the sponsor and the Committee of Jurisdiction.
We don't have a motion yet on the floor, but one of the things, we have talked as a board about that very issue, and what we want to make sure is that it doesn't add additional cost to the counties by paying for 2 people instead of 1 person. I'll kind of go back to what Commissioner Duda was talking about is, you know, it is for the kids, but we have to be cognizant of the cost, which I think this board obviously always does. But in the writing of that, and we supported that type of an arrangement where there could be more of a social worker doing the social worker work and attorney doing the attorney work. But again, it's going to also depend on how it comes out in the legislation in terms of who pays for it all. So I do need a motion on the floor about LB 15, and if that were to include the amendment about adding the bifurcation of duties between a social worker and a GAL.
I will move that we support LB 15 and the amendment.
Okay. And I would like included in there that we are just, again, cognizant of the cost of that bifurcated system. We have to watch for that.
Yeah.
Commissioner Kavanaugh?
Should be clear that, you know, we support LB 15 whether this amendment is attached to LB 15 this year or not. Yes. As the underlying legislation goes forward, we support it, but we also support the amendment concept. Thank you.
Commissioner Borgeson?
Yes, Commissioner
I'm sorry,
Boyle.
my thing isn't working, I think. Commissioner Duda was here last night.
His machine is blank, his machine is blank just like his mind.
The mic still works, though. One of the other serious, I think this is a great attempt at solving the problem, and I hope it works. There is still a huge flaw that I've observed and heard from judges and so forth about Health and Human Services, that it is an absolute revolving door, has been, And what happens is, many times, and this judge that I talked to told me that a request was made for a psychiatric evaluation. And the person who represented HHS didn't know the difference between a psychiatric evaluation and a psychologist. And so the person came in and had the wrong kind of assessment. And then the other problem is that was actually not a bad result. The worst result is the high turnover when everything's all set, everybody's there, the guardian ad litems are there, all the people, all the parties and all that stuff, the judge is there ready to roll. And in walks someone who says, I just started yesterday, I don't have anything. And so then it's postponed for 2 months and all that sort of thing. I think we need to ask Senator Chris to get into and barrel down on HHS. And now we have a governor, I think, who is in tune. Finally, we have a governor who's got an open heart to listen to some of these things. And it's really cool that the First Lady was involved in this sort of effort. So I think we have a rare opportunity to ask the governor and Senator Chris that this is a problem. HHS has to either start paying people real wages. I don't know what they were doing. They have to be sure that they've got people who just aren't walking right in off the street, who have no knowledge of what in the hell they're getting into. This will upgrade tremendously if we have a professional staff that, I'm not saying they're not dedicated or anything else, but we need a professional staff that'll stay, that needs to stay. They need to be paid enough, and I think this is a step in the right direction and certainly worth a shot. I think it'll probably be more expensive, but I just think, I'm sorry, that's what's going to have to happen. So I support this. But let's ask Senator Chris to look into HHS and make them show up prepared.
I know Senator Campbell is very much involved in that as chair of the Health and Human Services Committee, looking into that. And I think we'll be hearing more about some activities around that.
One other comment I want to add, that in the end of all of this, one of the families that was here today I was involved with in picking up a grandson at a facility in Fremont and bringing him home with the grandfather. That was, it's a ridiculous story. But the grandfather came with me, and I asked to go into the room where the boy was staying, and his belongings were in a box about this big. And the reason is this was the 17th place this kid had been sent in 12 years. He was 12 years old. He was also at that place after we left. We brought him back, but he was also charged with assault. And he was not a big kid, but he was, I don't know, normal age for a 12-year-old. And one of the other persons there, who was a ward of the state, made a racial slur to this young man. And to the young man's credit, he leapt up, and this probably isn't, I shouldn't have said it to his credit, but he leapt up and grabbed the guy by the neck and threw him to the floor. And before it was over, the guy had passed out. Well, he was charged with assault. Well, he had been called a racial slur, and I think the response was probably appropriate. That happened twice to this young man, which is why he was brought into the courtroom in chains, leg chains, 12 years old. Now he's in Michigan. Anyway, hopefully somebody who was paying attention, could have helped him. He had legal counsel, I know who it was. They're adequate. But the social aspect was missing, which is what hopefully this will bring about. So I'm sorry to drone on about it, but this is a big issue, and hopefully we can bring some peace to these families that are under such pressure.
Commissioner Rogers?
I was just going to suggest, I know, we're going to have a new director here coming in February or March or something to some degree, and, I would just think that if we can ask Mike and Sean if they can touch base with her, and I think we should just invite her down when the board's off. I don't know if May is enough time, because I'm sure the person will be trying to soak everything up, but at May we got a day off sometime around Memorial Day, and hopefully they'll be in the latter ends of the session, and it may be, hopefully she would receive an invitation from the biggest county, and I think they should probably start working on that now to get on her schedule and just invite her down.
I definitely can start working on that. That's a good idea.
Good idea, I think.
And, I know we have worked literally on this issue for good number of months prior to where we are today. And Commissioner Boyle, I still give him kudos for stepping up and helping that family out with that little boy. And so this piece of legislation, why we have a lot of important stuff always on our plates, this one is really personal, is really important to us. And so we're glad, again, to see first steps. We know there's a lot of work, but for those of us who, I guess, have been extra close to it, we're very happy to see this be beginning to take shape. So with that, please vote.
Motion passes.
We do have a few other pieces of legislation that our Assessor Register of Deeds would like us to talk about today. Good morning.
Almost.
Yes, it's still.
Diane Battiato, Assessor Register of Deeds. In reviewing some of the bills, both regarding the Register of Deeds section and the Assessor section, there's a few that we just wanted to bring to the attention of the board. Support, opposition, and neutral. So I believe you received a copy of all of those. I just wanted to go over them briefly. One that is not on the agenda, on your list is LB 492. And 492 is a revisit of our original LB 14, which was the Register of Deeds Technology Preservation Fund bill. In its original draft and passage, it had a sunset provision in it, and that sunset provision was for 5 years as of January 1st, 2018. This increase in this revenue addition would go away. LB 492 is taking a proactive approach to that and wanting to eliminate the sunset, take the sunset off. And I would really like to talk a little bit to the board about why I feel we should actively support this bill. It eliminates the sunset. It has also been drafted, it's a NACO bill. It's also been drafted to not only eliminate the sunset, but to also open up the opportunity for the funds to be used not only, it's written exclusively for Register of Deeds, for land records, preservation, and modernization. What it has opened up is the avenue for those offices who have combined Register of Deeds with assessors, that they can still use the funds, because hopefully those systems will eventually interact with each other, and it would not prohibit the culmination of the use of those dollars. At first, we really thought against that, but they rewrote it in wording that made sense, and so we're okay with that. And it does make sense with the counties as they've gone forward to combining the Land Records Official Office, the Register of Deeds, as well as the assessor. But the reason I really feel that the board and our lobbyists should take an active role in supporting it, as well as the realtors are and the title companies, is because for Douglas County and for all the county general funds in which you currently receive an equal amount of those increases for your general fund, and I understand you have a technology line item for those funds. If that sunset is not eliminated, those funds for not only the Register of Deeds and the land records, but also for the general funds will go away. Because as the original bill was passed, once January 1st of 2018 gets here, our fees that were increased to support these funds will revert back to our old fees. So there will be no excess funds for either account. So right now it was risen to $10 for the first page, $6 for subsequent pages. It will go back, if that sunset is not lifted, it will get back to $5 a page, 50 cents a lot. So the county general fund will also lose an extreme amount of money that has really benefited us for the last 2 years. So and Joe, we've been playing phone tag, so that's what I wanted to discuss with you, because you had questions about that, and as I read through it in its entirety, I thought, whoa, we really have to be proactive in getting this sunset lifted.
Yeah, Diane is right about that. It's about $400,000 that we've been getting, and we've been taking that money and putting it towards enterprise IT applications like the new budgeting system, Hyperion. We've funded with that, and it's really been a great, almost a godsend to us, because we knew we had these needs in IT and we didn't have a source of funding, and this is really allowing us to do a lot of things that we really needed to do.
Thank you. And on the land record side, we're saving, we've had 2 years of revenue. We have a little over $700,000 in our coffers, of which the general has the same amount, but they've used some. And it's going to actually pay for our new lands record management system without having to do any other requests for funding. It will help us with our maintenance through the years and also preserve a lot of our archivable documents. So it's very important that we, go forward in working to support this. I will be going down to Lincoln and speaking. The hearing is this Thursday at 1:30 in Governmental Affairs Room 1507. So I don't know if Sean or Mike, or if however the board deems fit to address that. That's when the first hearing is. So some other bills we have on the assessor side. LB 345. We urge opposition to this, and this bill would exempt the first $8,000 in value on owner-occupied residential property. To attain the exemption, the owner would file a one-time application between February 1st and June 30th. In subsequent years, the Assessor Register of Deeds office would be tasked with monitoring whether that property still fits the exemption. So the reasons we really oppose the bill is that it represents significant administrative mandate. Currently in Douglas County, there's an excess of 165,000 residential improved parcels. If you add mobile homes, it's over 167,000, so that properties that might qualify. Even if you subtract some of the percentages on rentals, we're still at a really significant volume of properties that would have to be monitored every year. So to put it in perspective, under the existing homestead exemption program, we process between 12 and 13,000 applications every year. If this bill passes, it also creates a lot of unnecessary red tape. The way the bill is written, if someone does not file that application within that proper timeline of February 1st and June 30th, he or she is actually waiving exemption. In the way the bill is written, the county board does not have any avenue to extend that timeline. So a lot of filers who might very well benefit from that exemption would be out of luck entirely. It also makes the Assessor Register of Deeds the residential police. It would require that that the property to be eligible has to be owner-occupied between January 1st and August 15th. There would be no way in subsequent years that we would be able to know if that property still applies, because they only have to apply one time for the exemption. So we'd have to figure out, whether or so those 140,000 residential properties are even still owner-occupied. So it's a lot of caveats that have not been thought through as far as the policing of this bill. We really feel, after reviewing this, that an easier way to provide property tax relief to improve property is to use the billing structure to do it. For example, if they pass the $8,000, this $8,000 relatively creates $160 in tax relief, actual tax payment relief. That $8,000 might be much better supported in doing it just on the billing side. For example, if you own a $150,000 residence, you're only billed on your tax statement for $142,000. It's a much simpler process. You don't have to worry about if or not they're owner-occupied, and it's just an across-the-board $8,000. So that's some of the reasons that we wanted to, bring the attention to the board, our concerns on this bill.
Commissioner Boyle?
Ms. Battiato, on the $8,000, who gets that? Everybody?
If it's an owner-occupied property.
Okay, but you have to figure out somehow who's, if it's owner
That's
occupied.
the issue, yeah. It's a monitoring nightmare that we would have, really relatively no way of policing that.
One of the, and I agree with you, except that there are other benefits that are given to property owners that are monitored that work. We don't have rent control in Nebraska, but major cities do, and it is based on owner occupied. And as soon as someone, you hear stories about an uncle dying and somebody quietly moving in and continuing to get that lower rent in Manhattan or someplace. But I mean, those are violations, but they do keep track of it some way. And also, Social Security benefits, I'm not saying that we could get anything out of Social Security, but if someone is residing in a home and receiving Social Security and they die, then the benefits stop. And how they find out, I don't know. But there are some mechanisms in place that are used by other governmental bodies to stop the benefits. And I think it'd be worth to look at it. And one of the things I get concerned about, because we see this often, are people who, for a lot of reasons, medical, dementia, whatever it may be, or just an older person like me throwing something aside and not responding. And so I'd like to see us keep the homestead exemption in place, that it's in place until the person dies. And,
okay, but this is totally separate from homestead exemption.
Yeah.
This is, and as I understand it, I'm going to refer to Mr. Goodwillie too, but as I understand it, currently our homestead exemption process, which would not be altered, this is in addition to homestead exemption, currently we get reimbursed our homestead exemption from the state. There is no reimbursement. Oh, there is, excuse me, that's fine.
No, it's okay. Mike Goodwillie, Douglas County Assessor's Office. Well,
I don't see that in your notes, Mike.
It's, okay, no, I thought I had it someplace. There are a number of property tax relief bills. Many of them reimburse the county for their tax loss, and this one does, but there are some others that don't seem to, so it's easy to get confused. I think to address, Commissioner Boyle, your questions, getting cooperation from Social Security for us would be a long shot at best.
Right.
With respect to your issue about, well, what happens when somebody moves, how does Social Security know? Well, there's some incentive for the person moving to tell them so that they continue to get their checks.
Well,
there is no incentive in LB 345 to somebody to say, grandma's moved or I've moved and now it's not an owner-occupied property. I mean, there just isn't any incentive for them to tell us.
Right.
Now, I guess the way I would characterize this is we're looking at 140,000 exemption applications to process, at least in that first year. We currently have 6 people who process 12 to 13,000 homestead applications. So I don't know how we would deal with the blizzard of the paper. It seems like an awful lot of travail for $160 when you could simply say, okay, all residential improved properties, the first $8,000 are going to be taxed.
Right.
And that's what we would advocate.
Right.
I mean, we're not necessarily opposed to the idea.
I agree with you. I do.
Okay. Thank you.
And that's what I was liking to hear, is that we can oppose
with
the
a
bill
solution.
with the inclusion of that idea.
Yeah.
That here's a better solution.
Exactly, and that's what we wanted to bring to the board, was our, possible resolution to meet, both ends meet in the middle.
Okay.
Well, and the other issue that occurs to me is, as I look at this, people are going to apply that first year, but with a pool of potential applicants of somewhere north of 140,000 probably, there are going to be people who file late. There are people who don't file at all, and they're going to get their property tax statement, and they're going to wonder why the hell they didn't get the benefit that their neighbor got, okay? So then they're going to be down here with bells on saying, I want mine. And we all love homestead protests so very much.
Yes, we do.
I think we'd see a bundle of these.
Well,
Commissioner Morgan, then you.
Let me ask you, I agree it would be a nightmare for your department. Now, let me be sure I understand. Are you saying that you would give everyone the $8,000 exemption would be the alternative?
For residential improved property, sure, that seems to be what they're aiming at.
Okay, so that would have a tremendous fiscal impact upon the county wouldn't it?
This one gets reimbursed, like homestead exemption does.
And they will reimburse us.
That's what this says
So
right
let
now.
me- All right. So if someone
Read
owns
that
rental
small print.
properties and you own 8 houses, are they going to get that same benefit even though it's not owner occupied?
That-
Everyone will get it.
If they adopt the alternative that we would suggest, that would be the cost of doing it. It certainly wouldn't be ratcheted down as tight as what this bill is intending with owner occupied, but I'm not sure this bill is really very possible to monitor. And so I think the trade-off is there may be some folks with rental properties that get the benefit in exchange for a program that's simple to apply and relatively easy to administer.
Yeah, I'm just not sure it's the right thing to do to be doing it. I mean, I appreciate that the first part, I agree with you totally on. I'm not sure that the alternative of giving that exemption to all is a
Exactly.
good option to offer, but I yield to, the other's judgment on that. So, that's all.
Okay. Commissioner Boyle?
Well, I agree with Commissioner Morgan. I have long been opposed to this ridiculous property tax giveaway where somebody gets $47 a month from the state, and it's $160 million worth of revenue the state's doling out. You can't even pay your Cox communication bill with $47. I mean, it just really is worthless in my estimation, and particularly because they're also giving commercial properties without naming anybody. Just think about, downtown. Think about Old Mill. Commercial property that's, whatever it is, they're getting a check for $190,000 or something. Doesn't mean a damn thing to them. And if the state really wants to get to the core of property tax reduction, in my opinion, it's something that they ought to do, and I think we're heading toward it, is they ought to take over some of the functions and the costs of county government and pay it themselves directly. The court system, eventually entirely into the justice system, a whole lot of those things, take it over. Look at what we're paying for, and we asked this in probation offices. We come up with a figure of just a little bit, not quite, but $1 million in cost to operate the probation offices in the state, in the county for the state. Anyway, I'd be for this $8,000, I suppose, but I am not for, not for giving it to, large apartment complexes. Those people are not property owners. They are not owner occupied. So I don't agree with that part at all.
Okay.
The next one that we would like to address to the board is LB 398. And this bill would eliminate business personal property taxes beginning January 1, 2017. Unlike a number of the bills proposed, oh, here's the one. This one does not get reimbursed to political subdivisions for their tax loss. So the reason we recommend opposition to this bill is because it would result in a huge loss of revenue for the political subdivisions in Douglas County. In the certificate of taxes levied report that our office files every state on December 1, for 2014, the value of tangible personal property was about $2 billion. And so this represents more than $40 million in property taxes, so it is definitely significant. It would further shift the property taxes onto real property and residential taxpayers. This bill provides a significant tax benefit for business owners, large and small. To make up the revenue, local subdivisions would have to be more reliant on those property taxes, real property taxes. But it would put more pressure also on the levy rates. If the real property values do not increase enough to offset the loss of business personal property value, with no property tax levy increase, then political subdivisions would then have to raise their levy rates to be able to generate the same amount of revenue for all the losses that this will take away. So just one to keep a watch on that, this one, because it's not reimbursed, I got them mixed up, sorry, but because it's not reimbursed, it would definitely be a loss of a lot of revenue for us.
So that's an oppose, not a watch.
That's an oppose.
Okay. All right.
LB 476, also a proposition for it. This bill would require by December 1st of each year, the assessor's offices provide a list to the state of all property that is exempt from property taxes with an estimated market value for each property. But the caveat is it appears that if passed, this bill will take effect this year. The reasons we oppose this bill is that it represents a significant unfunded mandate. Currently, state regulations specifically provide that the property record file for each parcel of real property have the current year's property valuations, quote, except for real property that receives tax exemption, end quote. Therefore, this bill would require the development of a market valuation for those properties when none has been previously required, meaning additional demands on the Assessor Register of Deeds appraisal staff. As far as the volume, as the bill is currently written, it does not distinguish between the type of exempt property for which an assessment office would have to report a value on, meaning that all exempt property would be included. It not only means permissive exemptions property, such as churches, charities, but it also includes all governmental properties as well, because it doesn't single anyone out. All told, in the first few months before this report is due, the Assessor's Register of Deeds office would have to value approximately 17,500 parcels of real property, including the city-county buildings, St. Margaret Mary's Church, Memorial Park, Creighton University, etc. So it's just a very cumbersome bill also. And the fact that its ensuance would be December 1st of this year makes it really almost impossible to facilitate.
Okay, Commissioner Morgan?
I was going to say, Joe Lorenz and I talked about it this morning, Mary Ann. Ridiculous. I mean, you're going to be out doing that work instead of the work
that we have
really
to do every
necessary.
6 years, yes.
You know, I don't know what the purpose would be to figure out how much St. Margaret Mary's or the cathedral or whatever is worth.
Right.
Doesn't even make sense. So make sure you keep us updated, but I can't speak for the board, but I think most of us support you on this totally.
Thank you.
Next one? Oh, Commissioner Kraft, sorry. Commissioner Kraft?
Yes. I'm going to go back a few years to a discussion I was reading at GASB, the Government Accounting Standards Board, that they wanted to require cities and states to list parkland and owned properties that were tax exempt on their balance sheets, at least as a footnote. Now, I don't know if it ever went anywhere, and I don't know if it's coming down the pike, but we should be aware of it and paying attention to it. Joe, do you know anything about that?
I haven't heard any initiatives on that. Kathleen?
This goes back 10 years, so.
Yeah, I don't think it's currently a hot topic, yeah.
Okay, thank you.
Any other ones?
I only have two more, and we're neutral, but we just feel that the board should be aware of the bill itself. The first one is LB 414. This bill would exempt from property taxation the real and business personal property of fraternal benefit societies, most notably Woodmen of the World. Our office will administer anything that the legislature wishes, but be aware that the 4 commercial Woodmen properties generated in excess of $1.1 million in property taxes in 2014. So that's just an FYI. Not that you all don't know that by now, but it's up down in Lincoln, so we wanted to address it.
Commissioner Boyle?
I'm sorry.
I'm just really curious. This is a question that doesn't have to be answered today, but I have a hard time distinguishing the Woman of the World's status. I would assume that it has been recognized by the IRS as some sort of nonprofit status. I mean, it reminds me of when we look at Greenbelt. We would inquire of the people asking for Greenbelt, what is your tax status with the Internal Revenue Service? And they would tell us, and that would help us determine whether or not they really are entitled to Greenbelt. It would help build a case. Well, I haven't looked into what Woman of the World's status is with the Internal Revenue Service. I'd be interested in looking at it, seeing what kind of a status they have, if it is indeed nonprofit of some sort. But how do you distinguish? I can't distinguish that building, although it's 30 stories high. I can't distinguish the use of that building from the former Blue Cross Blue Shield building and Mercy Road. I mean, I know that it's a healthcare facility, but they're making money. It supposedly is nonprofit. I mean, that's their status. I don't know what the IRS, again, what they have. But nonprofit is really not nonprofit. I mean, they're both making money. Obviously, you know, they wouldn't be able to operate if they couldn't pay their people, and they have a lot of money left over. You just have to look at all the buildings, clinics they're opening. So I mean, how do you distinguish between Allegiant and Woodman of the World?
Before you answer that, can I have Teresa Urick?
That's just what I was
type
gonna
in here
say.
for a
You
minute?
sure may.
Yeah, that's just what I was, I made a
I guess
note.
I shouldn't have brought it up. I realize now
Yes.
that we're before Turk.
And we were just doing an FYI.
Okay.
I guess
She's trying to find it.
Rosanna Dana will speak up. Never mind.
I will speak very loudly. None of the mics on this side appear to be.
Oh, it's on now.
Is it on? Oh, very good. Very good. Thank you so much for fixing that. Commissioner, if I may, the Teresa York County Attorney's Office, I believe the Turk appeals are pending with regards to Woodman at this time, and I know that there's discovery ongoing, and so with regards to the prior years, it would be my recommendation that we would allow that process to unfold rather than discussing it here.
I stand corrected. Thank you.
Okay.
Okay. Last but not least, LB 615. This bill would provide a property tax exemption for those over 67 years of age. It runs in addition to the existing homestead exemption program and would essentially freeze the taxable value of an owner-occupied property at the value it had when it was acquired, the effective date of the act, or the year the owner turns 67. So if the property was valued at an amount of $300,000 and the owner is 67, that taxable value would remain at $300,000 for that owner, even if the market assessed value climbs higher than that. We don't actively oppose this bill, but it lacks clarity and it does raise some public policy issues that I think the board should be aware of. The exemption would apply no matter what the income or the value of the home of the recipient. One of the virtues of the current homestead exemption program is that it actually targets significant relief to people of relatively moderate means. Under LB 16, a person with $1 million home would be insulated from any increases in value. Also, anyone that had $1 million a year in income. So there's no requirements like there are in homestead exemption. The bill uses homestead language and says that the exemption resulting from this bill can combine with the existing homestead benefits that a property owner might contain, but it isn't clear that those seeking the 67 age plus valuation freeze, if they need to file an application for it or not, and if not, how would the county be aware of who would be entitled to the exemption? And it also isn't clear about whether the tax loss from this program would be reimbursed by the state in the same fashion that other traditional homestead exemption programs are. Thirdly, if someone is eligible for the 67 plus exemption, but also wants to apply for the current homestead exemption, what home valuation eligibility amount would be used to see if the home qualifies? The actual value or the 67-year-old frozen value? Right now, we have a value limit on homestead, so there's so much confusion in how the bill is drafted that is just really, really a definition nightmare to understand.
Okay, Commissioner Boyle.
Well, I agree with you. It's kind of a Proposition 8 California approach to things that singles out, frankly, and being over 67, I just turned 68. Well, no, not actually. I actually turned to be 71. But the group of people who really, in my estimation, least need assistance, people my age, I mean, we have benefits that are unbelievable. You know, I mean, it's just, it's changed. Back in the 50s, people of my age group were in real poverty. Now, the homestead exemption is one of the solutions that helps, and there's other social services that will help make people, you know, pay their utilities and all these things, and the elderly. in my estimation, the people who need the relief are the people in their 30s and 40s who are raising families. I mean, they're the ones who are struggling to buy groceries for all those little kids who eat continuously. I mean, I've got 18 grandkids, and they're always eating. So, you know, they're the people who need the relief. So, I mean, I would like to see, you know, I always feel like when we're sitting here, we act like we're state senators or something, but I'd like to see something that would maybe freeze some valuations, that it wouldn't kill the revenue for the people, the governments that rely on property taxes, and then build in an automatic 1 or 1.5% increase annually that would solve all this stuff about going out and trying to value all the time. I think it'd be much more productive, but that's my opinion. But I really don't think this is a good approach to this at all.
Okay. So with all of the conversation we've had on these, are there ones that you would like, because whatever we take a position on then gives additional work to our lobbyist, and so we have to say, and if it is all of them, that's fine, but if it's not, are there any of them that you think are most important that we as a board would engage our lobbyist in working with you on these?
Well, I know the first one for support would be LB 492. I would greatly recommend us supporting that and get the lobbyist on that with that hearing on Thursday.
Okay.
I'm going to defer to Mike on the others. We wanted this as an information only for the board to use your judgment in doing that. The ones we opposed, the reasons that we opposed them are significant to us, and would in the end would be significant to you, because it would impact our need not only for staff, software, everything that we would have to do, and some of it affects revenue.
Right.
That one on reappraising all the property, I think
That would
the board needs to take
Yeah,
a position,
the
because that
exempt
would
property.
be unreal.
And that is 476. Was
Yep.
it 476?
Okay,
Yeah.
so we'll take
You got
a
that right.
position on support for LB 492 and oppose 476. Commissioner Kavanaugh?
A couple of things. First of all, I see that NACO has positions in opposition to these matters. We pay NACO to represent
To the
us in
ones we reference?
legislature. Yeah. I don't
Good.
know, particularly in light of the fact that some of these aren't going to be heard until a month
March.
from now, whether we might want to revisit them after we've researched them a little bit.
Do you have NACO's slant on LB 345
As opposed?
opposed? And 398?
Opposed.
And then we already talked about 476. What on 414 and 615?
615 is not, they didn't take a position.
Neutral.
615?
Okay, so we're neutral there.
414, I don't think we took a position on
Okay.
that one either,
Okay.
if I remember right. And some of these, I guess, again, the reason that I like having them brought forth before the hearing is because sometimes they come up so quick, and we don't have meetings, and we didn't have our schedule. If we can get as much as possible out of the way that we can do as a board early, that's sometimes better. And those that we watch, you know, we just always
We
bring
just
back.
watch,
So,
right.
But those two, the 476 and the 492, were there any other ones that you wanted us?
Other
Or do you
than
want to just
NACO?
report back after?
Well, we would, I mean, if NACO is opposing 345 and 398 as well, we would
Yep.
stand with them. We know they're going to offer something on the bill, some sort of some sort of testimony, but we wanted to provide the board the opportunity to weigh in if they so chose.
Yep.
What we didn't want to have happen is somebody from the board say
And
to
then
us,
not know.
hey, how come you guys didn't tell us about this bill?
Yep. No, I appreciate this very much.
Okay, thank you.
So, Commissioner Morgan?
No, I'll wait till she's...
So any of the other ones right now, except for those two?
That would be fine, those
Okay.
two.
So we're going to need a motion to oppose LB 476 and support 492. Is that Commissioner Kavanaugh?
That's not my understanding. I look at these as NACO's in opposition. And Diane, you're going to testify in opposition, correct?
Only on the one.
Not only on 476, 492 we're in support of.
You're going to testify on these bills, though, right?
Right.
Oh, tell him that. You are.
I'll be testifying on 345. I think that's up Thursday.
Okay. So you're testifying on 345.
And are we testifying?
Are you testifying on 492?
492.
I'm testifying in support of 492.
And what was the other one?
476.
476 is up, I think, I want to say March
5th.
March
The ones
5th.
for tomorrow are 345, 492, and 615.
Okay.
Correct?
We are preparing some written testimony for the committee on LB 615. We will testify I will testify verbally on 345. 210, I think, was neutral. We're not talking about that. I think Diane is testifying about 492 in front of another committee. And then for the 5th of March, 476 is up, and I have prepared some remarks for Diane if she wishes to testify.
Okay.
So I think what you want, though, from us is to know that the board is also supportive, so when you're sitting there, you can say, I've presented this to county board.
The support or
and we
the
are.
opposite, right.
So I think we need to give that is
Right.
what we're doing.
Yeah, so we can go down and talk pretty, on behalf of a unified front.
Right.
Right.
And they ask that a lot of times when we're down there, so it's important that we
Definitely.
do that.
Do we need to have a vote to
Yeah.
do that?
To declare an emergency?
No.
Put it on the agenda?
No, we haven't done that in the past on legislation. We've been able to
It's
add
not on
it
the
if the
agenda.
hearings are, unless that's changed.
Yeah, I think we'd just be voting that we're supportive when she goes down, that she knows she has our support if we do have a majority.
I understand, but am I right that things are supposed to be on the agenda before we vote on them unless we declare an emergency?
They, in the past, during legislation, during the time the legislature's been in session, it has been an open, bring forth, because of the hearings and because of things coming up, that we have not had to have it on the agenda. It could be added as we speak because things are moving. Now, if that's changing, then I need to know that. Commissioner Boyle.
Well, that is exactly right. I mean, I know that we had this discussion, but it's been a couple of years since it came up, I think. Because of the legislative activity that it happens so rapidly, and they are public bills, so they're not any surprises to anybody who wants to look into it. We have been able to take stands, and I think it's important that we continue to do that so that our positions, Ms. Badiatos, for example, are reinforced by the county board. We've sent letters based on action that came up quickly, and I think it's perfectly legal to do so. It just makes good sense. It's common sense.
Without an emergency.
Well, I mean, yeah, without an emergency. It's kind of like, if part of the building's on fire, you don't have to vote to call 911, react, do things, take a position.
Teresa?
Teresa York County Attorney's Office. I don't particularly, the analogy of Commissioner, if the building was on fire, that certainly would be an emergency.
Yes.
And so I don't know.
Some of these bills are
that analogy is addresses the idea that you don't have to declare the emergency, if I may say that. My concern would be that the purpose of having, I thought that we had a similar discussion with regards, maybe not on legislative, but I thought we'd had a similar discussion previously. My concern would be that the purpose of the agenda and putting items on the agenda is to give the public notice that they can come and speak upon an issue. And so I do have a concern if the board were to want to take action on a specific item that was not on the agenda. I do have a concern. What if there are members of the public that did want to come and speak with regards to a certain legislative bill? And I understand the dilemma that the legislature is often moving very quickly, and this board doesn't meet for the next 2 weeks. And I believe probably the hearings are coming up during that time period that the board does not meet. Whether it meets the definition of an emergency is also an interesting question. Emergencies are things that are usually typically not foreseen or things of that nature, and perhaps it does qualify since the board didn't know the dates that the legislature was going to set the hearing, and they could not predict the date that the hearing was going to be set. That's possible. I don't have that information with me today. So I think my preference would be that the agenda would be as succinct and as complete and as accurate as possible so that it would provide the information that it's intended to.
Commissioner Boyle?
Well, I think that, to suddenly change this procedure, I can understand, but these are legislative bills that come up that affect the well-being and the revenue of the county. They're important measures that could have serious financial impact on us and other impacts as well. And to me, to say that we can't take a position on it really neuters us. It takes us out of the realm of discussion. I mean, I believe Commissioner Borgeson has been attending NACO meetings and has been voting what she believes to be the position of Douglas County government on these issues. So,
No, it's on NACO. I don't go by saying this is Douglas County.
No, but you're voting on it.
Yes.
Well, and I think that, that is what this is all about. I think we need to take positions on these legislative matters.
We have to.
I think it'd be terrible if we couldn't take a position on things. It doesn't make any sense.
Commissioner Rogers and then Marcos?
Yeah, I recall the situation to be, about 2 years ago, 2 to 3 years ago, legislative updates only came on the agenda in legislative session, and then it was out of session. And we didn't have it on, and because of that, we started putting it on monthly just to be covered.
Right.
And we've always, whatever came under there, particularly in session, if it was under there, if a bill came up, and we already did a couple of them this year, we put one down there and pass it. If it was out of session, and we need to talk about one, then we note it, wait a week, put it on. And so that, there's already precedence for it.
Marcos? No.
So I'm not a lawyer, but I think, is it stare decisis that has some precedence?
I guess to make, I don't care, it's not that big a deal. If somebody wants to make an emergency so we can add these just so it's on the record, then let's do that and move it along. So, does somebody want to?
Well, I'll make a motion that it's an emergency. I think this is really unnecessary, but I'll make the motion that it's an emergency.
Okay, is there a second, Commissioner?
Wait a minute, I had a request.
I know, I'm getting there, Commissioner Commissioner Kavanaugh?
Yeah. This isn't, we don't take a position on these bills. We can take a position on these bills tomorrow, next week, whatever. This bill is going to be heard tomorrow. It's been on the hearing agenda for 2 weeks. And you all know, being in the legislature, whether or not we pass a position today for the hearing tomorrow, or we send them a letter of our position in the order of business that we usually conduct business in, isn't going to make any difference on our weighing in on this issue. What is going to make a difference is, do these agendas represent what we're going to do, or do we have to talk to somebody, walking in the door about additions to the agendas? I'm more concerned about our rules, following our own rules. We'll take a position, and I don't disagree at all with the assessor's read on these bills. I think NACO has the bills for the most part covered, with the exception of 615, and the assessor is going to testify on 615 on her own, which probably would be a more informed opinion than anybody on this board could possibly give. So, my question is, should we have some standard procedure other than we've always done it this way, or we've never done it that way, which I don't consider a legitimate standard procedure? And if there's a rule in place, should we at least go through the motions of following our own rules? If we want to declare it an emergency on these bills, go ahead. There isn't an emergency in the legislative scheme of things. We will have plenty of time to weigh in on these bills, whether we show up at the hearing tomorrow or not.
Commissioner Boyle?
Well, Commissioner Kavanaugh, the standard procedure is to allow discussion and to take positions on these bills as they come up. And we normally don't have the luxury of this bill being heard in March or sometime. Usually it's the next day or something of that nature, so that we don't have the luxury of sitting around and talking about these things and and then acting on them 2 months later. It's really urgent. I really don't care. I've always I've tried to be a realist about the talk that we have about legislative bills has all the impact of a falling leaf. Really, what we sit here and debate is a little bit silly because we really don't control things. So what we're really doing is trying to say to the legislature, the state senator, take another look at this. We don't really totally agree with it, and try to get them to shape something that benefits the taxpayers and the citizens of the community. And that's been our standard procedure. Or usually, because we don't have the luxury of months later having this hearing. So I frankly don't care. I don't care if we take this off the agenda entirely. I really don't care. Okay. We can leave our independently elected county officials to go down and say things. So I mean, I would be for taking this off the agenda entirely and quit wasting time. I don't really care one way or the other. It doesn't break my heart.
Commissioner Kavanaugh?
Well, I mean, we could certainly do that and move on. I'd be for that.
Commissioner Morgan?
Well, the only thing I wanted to try to do here is if Diane's going there, I want to at least have her say that, hey, I presented this to county board. They're in support of my testimony here also because they see this as detrimental or they see it as positive. And I think that's what I'd like to give Diane the tool of, and that's why she's here to do that. And I'm appreciative of you coming here and talking to us about it. I'm also was going to say at the end of your talk, I'm appreciative of your hands-on management that I've seen. And I also want to compliment Larry, who I talked to a number of times on Friday afternoon and last week about some matters that were calls to me from citizens, and I appreciate how you handled that, Larry, also on Diane's behalf. So,
Commissioner Kraft?
Yes. Commissioner Boyle mentioned that we had had a similar conversation years ago, and I wanted to have the board follow by Robert's Rules of Orders, and I was pretty much unanimously shot down. But Diane could easily go through us right now and ask each of us verbally, and she could always say it's unanimous if we all say yes, without us taking a vote.
Put me on the spot here.
And that's what I would suggest. Why don't you just ask us how each one of us feel without taking a vote? Because I too feel that we run a very sloppy ship the way we run these meetings.
Well, it's funny to me that all of a sudden it's sloppy when this is, to use your phrase, the way we've done it and proceeded all these years in doing it this way. And
well, I did attempt to change it.
So again, there's also been, which it's very nice of you to bring your bills that affect your office to the board, because in the past there's been elected officials that have been criticized that have been down there testifying and we knew nothing about it. And so I, for one, very much appreciate it. I've been down there and I've watched, I've heard, and I've listened, and I've been asked, where is the county board? Where is your county board? Where is the county board? Where are you guys on this issue? And so while it may not make a huge impact, it's something that they do ask and they do look at. And so this is our job. Our job is now during the legislative session to look at legislation that will affect the county. So we have bills that were brought by our assessor register of deeds that do have an impact on the county. And so the hearings are Thursday. So we don't have time to wait and put it back on. And that, again, was one of the reasons why we said we were going to put this on as legislative issues every week. When things come up, we'd be able to act on them. So to move things along, I will ask again whether this board wants to take a position of oppose on LB 476 or support on 492.
I'd make a motion that we move forward as Diane's requested on her request and be supportive.
For both of them. Yeah.
I'll second that motion.
Any other discussion?
So which bills are we taking stands on?
On LB 476, we are opposing, and 492, we are supporting. Please vote.
And just for the record, I'm supporting all of the things that you did. State your position on, just for
Thank you.
the
Thank
record,
you.
okay?
I would like to also offer to the board, we had referenced that there's a few bills that we are going to send just a letter of, for clarification or opinion down there, and I will CC all the board members of any correspondence that we're sending down.
Great, thank you, Diane.
Thank you.
We have, is there any other legislation? There is the bill LB 119 that Commissioner Boyle, you were talking about earlier in terms of certain sentencings for imprisonment. So we'll put that one back on. You do have a copy of it now, so if you want to take a position, you can let me know and we'll put it back on there.
Mark is here too, Mike.
Yeah. Dr. Foxall? I'd like to ask Dr. Foxall to speak about that, and then we can make an informed decision.
Good afternoon.
Good afternoon.
Mark Foxall, Director of Corrections. I'm just going to speak briefly to the summary of LB 119, and I would add that some of those...
Could you put the microphone real close?
Sorry.
Thanks.
This is Mark Foxall, Director of Corrections. I would speak this afternoon to the summary LB 119, which basically is an attempt to change where sentences of imprisonment may be served. Sentences of 1 year or less, according to this bill, may be served in county jail, except for some provisions that are included with regard to particular felonies. That will definitely increase our population. Last year, approximately 259 inmates went to the state that were less than a year. So if those individuals are to remain here in our facility, that will definitely increase our population by 30 to 50 inmates, or it would cause us to open up a housing unit, open up and staff another housing unit. So if we run that per diem against those numbers, it's probably about a $1.7 million addition to the budget to house those individuals here. I don't have estimates with respect to medical cost. It's hard to estimate what the medical cost would be of those 259 people that left our facility. So that could potentially be another cost to us if they were to stay in our facility. Also, this less than a year to remain at the county jail language is also embedded in LB 605 too, just not in the detail that you see it in 119. But I would also call your attention that California, in their public safety realignment, has done this also, and they have kept a lot of felons in jail environments. Jail environments are short-term facilities, and they are not meant for the long-term stay of state inmates. And the experience in California, and I just came back from a conference in California and talking to some of my colleagues there, they have noticed a pretty marked increase in staff assaults, inmate on staff assaults, inmate on inmate assaults, contraband, dangerous weapons being found. This is a concern, and I had this conversation, it was Sunday, with some of my peers in California, and they are concerned what the realignment has done in California, and I would voice that concern for us here as well. And my other concern, if 1 year could be 2, could be 3. So those are something to look prospectively towards as you review this legislation.
This is a recommendation from that Council on State Governments report, isn't it? Which, again, 605, I think, has more of it, but this is a piece of it.
Yes.
Yeah. Commissioner Boyle?
Dr. Foxall, do you have a recommendation?
Yes.
What is it?
With respect to 119 and the language in 605?
Yes.
I'd be very concerned if this passed.
So you're opposed to which bills again?
119 and there's language in 605, about 90 pages. So there's a lot in that bill. So I wouldn't be in opposition to everything that's in 605, but the language with respect to incarceration in a county facility for a year or less in felonies, I would be opposed to that language as well.
Well, I would make a motion that we oppose LB 119 and also LB 605.
On LB 605, I think, you're not done yet going through all that.
No, there's a
So
lot
we wanna
in
wait till the
605. So
summary.
if I could come back, and there's some probation language in there too, and it's a huge bill.
Okay.
So, and it has some direct and indirect
So are you changing,
particular consequences for us, and kind of an if-then statement, so.
Mike, you going to change your motion to
Sure.
just 119?
119.
I'll second.
Okay.
Okay. Any other questions, Commissioner Kavanaugh?
Is this bill on our agenda?
Nope.
Okay, so we're back to the same question about we either have stuff on the agenda or we don't. And we have a procedure, if we don't, to deal with it, which is we declare emergency, right? Am I right here? No?
Not for legislation.
We can't declare an emergency for legislation, is that correct?
No, we
I'm
can't.
asking the county attorney.
Wow.
Teresa, you're a county attorney. I believe, Commissioner Kavanaugh, that there could arise a situation where you could declare an emergency for legislation. But the idea of the case law that exists with regards to an emergency is that it's something that's unpredictable, unforeseen, or a series of events that lends itself to like a crisis. And so it's possible, I suppose, if the meeting was scheduled the next day for the hearing at the legislative chamber and it was not known to this board, perhaps that would qualify. But I don't know that the regular process that occurs at the legislature would necessarily create an emergency.
Okay, but we're not legally prohibited from declaring an emergency if we want to, right?
No, we didn't.
You could declare an emergency. The question would then, I suppose, become, did it fit the definition of an emergency?
But who would question it?
Well, you could have a citizen that could take issue with that, Commissioner, and say that, in fact, there was a violation of the open meetings law because, in fact, there was no emergency, and yet you amended the agenda.
So the violation of the open meetings law would be foisting something onto the agenda at the last minute without due notice, correct?
I would direct, the answer directly is yes. I would direct the commissioners to 84-1411. It's the first subsection, and it talks about the public body shall have the right to modify the agenda to include items of an emergency nature only at a public meeting. And so you can amend the agenda, you can declare the emergency, but it should fit the definition of what an emergency is.
Okay. Is there a way, without declaring an emergency, to amend the agenda?
There is, but there are time frames for it, and it's also contained in that subsection. So, except for items of an emergency nature, the agenda shall not be altered later than 24 hours before the scheduled commencement of the meeting, or 48 hours if it's outside the corporate limits. So there are procedures for amendments.
Okay, so our just previous act, previous to this one, violated that restriction, right? We did something that wasn't on the agenda, and we took official action without either declaring an emergency or having it declared, was it 24 hours beforehand?
Commissioner, if I may, I would reserve the right to respond to the board and that inquiry in an executive session if you would like me to respond and delve into that further.
Sure. I'm going to probably abstain again on this one, not for any substantive reason, Dr. Foxall. I actually agree with you on the position on prisoners. But because, we're obviously way out of the parameters of our own open meetings law and the procedures that we should follow. I don't have any problem with doing this correctly, but I do have a problem if we make an exception now, how many more exceptions we're going to make. This is, if we understand what our legal counsel is telling us, not a situation that meets any of the exceptions for either an emergency or the amendment of the agenda. So.
Any other questions or comments, Commissioner Boyle?
Well, it's I don't believe it's an emergency. I don't think it qualifies, Mr. Kavanaugh. But this is a procedure we did adopt several years ago because of the nature of legislative activity. As you know, things happen fast. And sometimes, when we endorse something or oppose something, by the time that message gets to Lincoln, it's an entirely different bill. So it is, I think, necessary and really essential for us to take positions on bills such as this that have a dramatic effect on the operations of that facility. The average stay of a person at the facility is something like 17 days now, something like that. And this bill apparently would call for stays of up to 3 years. We're not built for that. We can't afford it. The state continues to hoist these things on us. So I think we have a responsibility to taxpayers to speak up. We have never had a complaint about this activity. On the contrary, last week we had a complaint because something showed up on the agenda on Tuesday that wasn't on the agenda on Friday that dealt with the subject we heard today about juvenile court and guardian ad litems. We had a lot of complaints about that. People watch our agendas. They know that we're considering these matters, and I don't think they expect us to list them. And I'm very comfortable with voting on them and discussing them. On the other hand, I do know that sometimes this is kind of futile. And as I said, I wouldn't have a problem if we abolish the whole thing, take it off our agenda entirely. I don't care. But I do care to the extent that I think it's important to speak out when we have a competent and well-respected director telling us this is a problem. So, I mean, like your alternative, we just sit here and listen to them and then adjourn. That's not responsible.
No other questions or lights. There is a motion to oppose LB 119. Please vote. Oh, sorry. Commissioner Duda.
I don't mean to make much ado about nothing, but this is kind of an emergency in my mind. I mean, we didn't know that this issue was going to be coming. It is. We don't meet again for 3 weeks. To me, that qualifies as an emergency, something that's coming along that we didn't foresee. We could just put every single bill that's in the hopper on the agenda. We used to say other legislative items. We don't say that anymore. There's absolutely nothing on here. Commissioner Boyle just got done saying people do watch the agendas, do pay attention. They got no clue that we're acting on this. I don't understand why we don't just say, we didn't see this coming, we should act now, that constitutes an emergency, let's take a stand. It sounds pretty simple to me for those people that are watching the agenda to explain to them why we're acting on something that isn't on the agenda. Thank you.
I think to rectify this so we don't go through this every week when we have this is if people want to change a process which we've had for years, then bring a solution forward that you want to do. But as chairs and previous chairs, we have followed this method during legislative process, and so it's not me as the chair making a mess out of the legislative issues. It's a process that we've done for years. If you want it different, bring it on, change it, because I don't care either. I'm following what we've been doing. And if people don't want to do that now, bring it on. Bring a change on. That's fine with me. Please vote.
Pass.
Thank you.
Thank you, Doctor.
Thanks, Commissioners.
The next is a resolution adopting a policy related to the dependent eligibility verification audit performed by Aon Hewitt. This was laid over from Tuesday, February 3rd, 2015. And I think all of the questions have been answered on this.
Motion to approve.
Is there a second?
Second.
Any other questions or comments? Please vote. Motion passes. We do have need for an executive session for litigation. Is there a motion?
So moved.
Second.
Please vote.
Madam Chair,
Yes.
just so you know, there's cake and ice cream down in the clerk's office, even a little gluten-free chocolate to celebrate Tom's birthday, so
That's not
you're
on
all
the
welcome to
agenda.
come
We can't
down.
go down and do
Thank
that.
you. Okay, thank you.
Emergency, we're hungry.
Are we voting on this?
Only 2 votes to go.
Well, I'm trying to vote.
I'll vote.
Hey, Sam, will you report this as malfunction? You got me?
Did you get
All
enough?
right.
Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. Spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. For spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. For spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed his grace on thee, and crown thy good with brotherhood from sea to shining sea. beautiful, for spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, beautiful, for spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, beautiful, for spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, beautiful, for spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood, from sea to shining sea. spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea. Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty above the fruited plain. America, America, God shed His grace on thee, and crown thy good with brotherhood from sea to shining sea.
Well, the system isn't going, but...
I vote yes. Commissioner Kavanaugh, Commissioner Duda, Commissioner Kraft, Commissioner Morgan, Commissioner Rogers, Madam Chair. Motion passes.